The case is now being recorded. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much, and welcome to the Appeals Court. I'm Judge Milkey. With me today is Judge Hand and Judge Grant, and together we make up the panel for the 6 cases we're hearing this morning. Our first case is 2020 P 838 Commonwealth v. KLEIN. We're dealing with 2 veterans of the court, so I don't need to go over the rules. I will say that 15 minutes is ordinarily not a great deal of time, so I would urge both parties to cut to the chase. We have read the briefs and are familiar, therefore, with both the facts and the oral argument. So with that, I will turn it over to Mr. Smith.
Thank you, Your Honor. Joseph Smith for Mr. KLEIN. May it please the court. Your Honors, as this court's aware, the protections of the Fourth Amendment to the United States Constitution in Article 14 of the Mass Declaration of Rights are at their strongest when the police seek to search a residence. And generally speaking, such a search requires a search warrant supported by probable cause. Whereas here we have an investigation concerning allegations of drug distribution. And the police seek to search a residence in connection with that investigation. There has to be a substantial and adequate nexus between the defendant or the target or the suspect, if you will, drug enterprise and the target residence itself. Substantial basis, as the cases tell us, is not enough. Strong reason to suspect is not enough. There has to be probable cause to believe to establish that there's a substantial basis between a nexus between the defendant's suspected drug distribution or drug delivery service enterprise and the target apartment or target residence. So,
counsel, putting aside the issue of which unit at the address we're talking about, why isn't this case well within the existing case law, be it Clagon or a number of other cases?
Your Honor, in many of the cases, or perhaps most, particularly those that are many that are enumerated in the appendix to Commonwealth versus Andre Fields, those cases involve ordinarily allegations from confidential informants that they purchased drugs from the target apartment itself, or that they've witnessed drugs at the target apartment itself, or tips at all that connect a suspect to a particular target apartment. We don't have that in this case. We don't have any tips from confidential informants that connect Mr. KLEIN to apartment 2 of 162 Corey Street. We simply have police surveillance that puts him at that building, at that premises, but only over the course of a 2-month-long period of surveillance. We have a total of 2 instances where the police allege to have witnessed seeing Mr. KLEIN inside of apartment 2. The police don't indicate how long he is seen in that particular apartment. And it's noteworthy that over the course of this 2-month investigation, the police never witnessed or never aver that they witnessed Mr. KLEIN leaving directly from apartment number 2 to go to a controlled buy, or returning directly to apartment 2 following the conclusion of a controlled buy. That's something that the cases emphasize and indicate are important. And it's not as though under these facts the police were seemingly unable to make those observations. In fact, with respect to the instances where they do allege to have seen Mr. KLEIN in apartment 2, they seem to have done so by observing the property itself from the street. And there's apparently, according to what the facts are as alleged in the affidavit, there's a window that's essentially in front of the door to apartment 2 that the police can view or see through. And they, in one instance, note that Mr. KLEIN walks past the window to go into apartment number 2, but they never aver that they see this occur immediately prior to a controlled buy or immediately after a controlled buy is completed. That's important. And we don't have any other real information connecting Mr. KLEIN to apartment 2. The utilities themselves are registered, or they're under a name.
But he's got lots of connections. I mean, he's seen a lot at this address. We know he's at this address directly before the sales and typically return directly after the sales. So isn't the only real question in play which apartment he was tied to?
Well, that's correct, Your Honor, but that's significant. In order to a residence, a search warrant to search a particular apartment in an apartment building is not the scope of that warrant does not extend to the entire building itself. And if anything, the connections that tie Mr. KLEIN to that building more strongly point to his connection to apartment number 1 that's tied to a Mr. Nally than they do apartment number 2, which is registered to an individual named Thomas Pariseau.
Is it possible they had probable cause to search both apartments, 1 and 2?
I don't believe so, Your Honor, because of the fleeting observations that they made of Mr. KLEIN and no other real evidence that's tying him to that particular apartment. Again, I would just circle back to the fact that in a case where they are able to put eyes on this building, and they are able to see, presumably from the street, Mr. KLEIN on one unspecified date in November of 2018, and another, I think, was November 30th of 2018. They're able to see Mr. KLEIN go into that apartment 2 a total of twice over the course of 60 days, but never claim to have seen him leave from that apartment or return to that apartment.
But counsel, you're making it sound like the police have unlimited resources to camp out there and observe this, what's going on 24/7. And you say that, oh, over the course of 2 months, they only saw him in this apartment twice. Well, that's the only information we have was that he was, of the 3 apartments, he was seen in this apartment. Now, I understand you point out that the police don't expressly state that they didn't see him in the other apartments, but isn't that something that could be inferred from this affidavit?
Well, I would like to address your question in 2 ways, Your Honor. One, the first part of your question related to the resources of the police department that's investigating the case. And I would say that the police here weren't without reasonable investigatory options. So, for example, as was the case in Escalera, the police could have simply spoken to the property manager or the owner of the property to try to gain more information on who was residing at or lived at both apartment 1 and apartment 2, or the residents of every apartment unit for that matter. Also, for example, in another one of the cases that is cited in the appendix to Andre Field's Gallagher, the police appear to have concocted some sort of ruse where they actually went to the apartment that they were surveilling itself and knocked on the door and spoke to the resident there, who it turns out was the defendant, and indicated that she in fact lived there. Or the police could have obtained an anticipatory warrant. All of these controlled buys seem to have occurred where Mr. KLEIN shows up to the location in a rented Nissan. The police could have obtained an anticipatory warrant for the Nissan. And in turn, they could have potentially uncovered additional evidence that may have been located in the automobile itself that could have confirmed or dispelled their beliefs about who the resident of apartment number 2 might be, or they might have been able to bolster the affidavit in order to supply probable cause to search the unit. But in this case, they chose not to do those things.
Well, couldn't the magistrate infer that speaking to the landlord would be fruitless based on the trooper's statement that upper level drug dealers often keep their apartments, their drugs or proceeds in apartments that do not belong to them?
We really don't know, Your Honor, because in this instance, the police seem to have made no effort to try to ask the property. We don't know who owns the unit itself. There's a property management company that maybe they couldn't confirm that Mr. KLEIN or anyone else for that matter had signed a lease or something of the like, but they might have been able to provide additional information on who is the person that's regularly residing at a particular unit.
Can the police infer, could the magistrate infer from the fact that the utilities to that unit were being paid in the name of someone who is deceased? What could be inferred from that?
Well, Your Honor, that's actually the police were never, in fact, able to confirm the Thomas Pariseau in question. So they located a Thomas Pariseau that had presumably or seemingly passed away, and then they claim in the affidavit, or Trooper Ledeen claims in the affidavit that he had conducted a search of all of the Thomas Pariseaus in Massachusetts and Rhode Island, and he had pictures of these individuals and didn't see any of these individuals at the property in question. But it's not clear what sort of search was done, under which databases, how exhaustive that might have been, and we don't know for certain that the Thomas Pariseau that Trooper Ledeen located that had passed away was the one that was connected with this apartment. There's a connection, a tangential, if even that connection between Pariseau or Thomas Pariseau that lived in Taunton, Massachusetts and Rhode Island, and Mr. Nally, who apparently had at one time lived in both in Taunton and Rhode Island. But given that this is located in Fall River, which is southeastern Massachusetts, I don't know that it would be that out of the ordinary to find two individuals that had both lived in both of those locations. So we don't know for sure that this person that Trooper Ledeen is claiming is deceased is in fact the Thomas Pariseau that's paying the utilities for that particular apartment. That's just, it seems to me to be speculation on the part of Ledeen and his affidavit.
Isn't there something in between speculation and certainty, where they had a reasonable belief that there was a dead person paying for the utilities?
Well, I mean, again, even strong reason to suspect is inadequate. So maybe the police had a hunch that this person was deceased and that someone else, in fact, was residing there. But my argument is that doesn't establish probable cause to believe that there's a nexus between Mr. KLEIN in apartment 2 of 162 Corey Street. And the burden on the police is not a substantial one to try to bolster their affidavit. And I think that that's important because as the concurrence in Andre Fields points out, there's a concern with respect to our jurisprudence surrounding search warrants. And the standard ought not to be lowered any further. And so in order to prevent the courts from essentially acting as rubber stamps for search warrant applications, we should put some stringent requirements on police officers that are applying for these warrants, particularly with regard to a residence, a home, where the protections of the Fourth Amendment and Article 14 are at their strongest.
Does it matter at all in establishing a nexus that this was a 3-family as opposed to the 144 unit building in Commonwealth v. Ponte?
Well, I mean, Ponte certainly addresses the idea that it's my recollection of Ponte is that it's more of a concern as it relates to nexus the more units are located within a building. But that case also, if I recall correctly, involved a confidential informant alleging that he had purchased drugs at the apartment itself. And in fact, that wasn't even enough to create a nexus between, if my memory serves as it relates to Ponte, that wasn't, the search warrant in that case was inadequate based on the confidential informant's statement that he had purchased drugs at a particular apartment unit within the multi-unit building. So I don't know that it's completely on point with respect to this case, but I think in this case itself, again, there needs to be more evidence tying Mr. KLEIN to apartment 2 in order to establish probable cause to search that particular unit. And the police here chose not to seek it out. And so because of that, probable cause here was lacking, and the motion to suppress should have been allowed. And if your honors have no further questions, I'm happy to rest on my brief.
Seeing none from my colleagues, we will turn to the Commonwealth.
Thank you, Your Honor. Good morning. May it please the court.
Counsel, you've suddenly gone mute on us.
Sorry. Hopefully you can hear me now.
Yes.
Okay. The denial of the defendant's motion to suppress should be affirmed where there was a nexus between the defendant's drug dealing business and the target residence. Even if the defendant did have some connections to apartment number 1, that does not negate the probable cause for apartment number 2. The police did see him enter and go inside apartment number 2 on 2 occasions during their surveillance. And the standard here is probable cause. It's not certainty. The police certainly don't have to exclude any possibility that the drugs or the contraband is kept at another location, that it might be found at another location. And if you look at Commonwealth versus Andre Fields, which is cited in my brief, in that case, the officer in his affidavit, he didn't state which apartment specifically the defendant left from when he was going to the controlled buys. However, this court held that the magistrate could infer that he left from apartment number 2 because the police had seen him coming and going from apartment number 2 on multiple occasions, and that was his usual practice. And I would suggest that that would be the same as this case. They saw him in apartment number 2 on 2 occasions. And so I would suggest that we could infer that that was the apartment that he was going to. In this case, they didn't aver that they had ever seen him in apartment 1. And I would suggest that the magistrate could infer that that meant that they did not see him in apartment 1. This was an experienced law enforcement officer who wrote the affidavit. You know, so I would suggest that certainly the magistrate could rely on that officer's experience in writing the affidavit.
But counsel, which way does that point cut? If it's a really experienced police officer trying to dress up the affidavit in the most powerful form for the Commonwealth, if in fact the officer had not seen him in apartment 1, why wouldn't the officer have said so?
Well, because I would suggest if he hadn't seen him go into apartment number 1, but they had seen him go into apartment number 2, then an experienced law enforcement officer would know that was enough for a nexus to apartment number 2.
No, I understand that, but my point is, why not make that point explicit that he had never seen him in apartment 1, as opposed to leave it to the courts to infer that from the mere absence of any mention?
Well, I mean, he could have forgot to put it in. It was a lengthy affidavit. He could have not thought that it was important to not put it in where they hadn't seen him go into that apartment. If they had seen him go into that apartment, I would suggest that they would have. I mean, an experienced law enforcement officer would know that they could have asked for. They're not limited where they can ask for the warrant to. If they had probable cause for apartments 1 and 2, they certainly could have asked for a warrant to apartments 1 and 2, as Justice Grant pointed out earlier.
What do you say in response to the argument that the trooper should have spoken to the landlord?
Well, I mean, I don't know how that. I would suggest he wasn't required to do that. They saw this defendant go into apartment number 2. They knew that it was being paid for. The utilities were in the name of a deceased person. The officer had averred in his professional opinion that this was a stash house, and that oftentimes, drug dealers put stash houses in other people's names so that the police can't find them, and so that they're not robbed, and to avoid their family being involved in their drug business. So I would suggest that the magistrate could rely on that opinion that this was a stash house and likely not even rented in the defendant's name. And if there's no further questions, I'll rest on my brief.
Seeing none, thank you very much. The case is submitted.
Thank you, Your Honors.
The case is now being recorded.
Thank you very much and welcome back to the Appeals Court. I'm Judge Milkey. With me are my colleagues, Judge Hand and Judge Grant. The next case we're going to hear is Commonwealth versus Spencer, 2020 P 313. The ordinary rules of oral arguments in the Appeals Court apply, so we have 15 minutes per side. Please keep in mind that we have read the brief, so we're familiar both with the facts and the arguments. So since 15 minutes is ordinarily not a lot of time, we urge you both to cut to the chase. And with that, I will turn it over to Ms. Riordan.
Good morning, Your Honors. May it please the court, Deborah Riordan representing Barry Spencer Jr. There's one issue in this case. Did the Commonwealth prove all the elements of resisting arrest such that the motion for required finding should have been denied? It is a position of the defendant, who feels very strongly about this, that they did not. And in particular, it's the third element that we're concerned about. Mr. Spencer did not use or threaten to use physical force or violence or use some other means which created a substantial risk of harm to the police. Now, when Mahoney came up to Mr. Spencer, he grabbed him by the hand, the arm, and he never lost grip on Mr. Spencer. Mr. Spencer tried to move back a little bit, but that was all he did. He twisted a little bit. But
Counsel, the jury heard that it took 4 officers to subdue your client. Why isn't that enough for the jury to infer that he was physically resisting arrest?
well, the time of arrest was when, I would suggest, is when Mahoney put his hands on him. And Mahoney testified he tried to take him to the wall and he couldn't move him. He didn't testify about what Mr. Spence was doing when he was trying to move him to the wall. That was a very—
The arrest, counsel, though, isn't the arrest until the point that the defendant is secured? Isn't that all part of the process of the arrest?
I would suggest that he was on the ground. He was on the ground. Officer Mahoney took him down very quickly by himself and sat on him. And they couldn't he was sitting on him and they couldn't get his arms out from under him. Now, it took 4 people to get his arms out because they just lifted him up. But Mahoney didn't have backup when he initially was watching all of the action he claimed to have seen. And when he went over to Mr. Spencer, and then he called for help afterwards, but he had him down on the ground and he was sitting on him. They just couldn't get his hands to put the cuffs on him. And I don't think that according to the case law, that did not rise to the level of resisting that is called for.
Counsel, how do you distinguish Grandison?
Grandison actually managed to pull his arms away. Mr. Spencer never, and break away from the police officer. Mr. Spencer never broke away, Officer Mahoney held on to him the whole time. He never had a moment where there was not, where Mahoney was not in control of him. That's how I would distinguish that. In Ocasio, the man was kicking against the cruiser. They couldn't put him into the cruiser because he kept kicking away. In Fort T, the man actually assaulted the troopers. It was not originally a resisting arrest. He was being questioned and then he assaulted the troopers. So they were arresting him for assaulting them and he kept assaulting them. This is very different, I would suggest. In Sylvia, there were 2 scuffles in Sylvia. There was one, the defendant got away because he slipped out of his jacket. The officer had hold of the jacket. He slipped away. There was another scuffle. In Montoya,
Could the jury infer that your client possessed the knife and that it created a substantial risk of bodily injury to the police?
the defendant was never charged with any possession of a knife. There was no knife it had allegedly been taken into police custody, and then at trial, it was not there. They didn't have a knife to show the jury. It was underneath him, but he was in a public area and he claimed he didn't have a knife. So I think that,
But surely the jury was not required to accept that.
that is true. That is true.
And in this case, if I'm remembering this correctly, your client did not actually testify. So
No, he did not.
his suggestions came in through his questions, which are not themselves evidence.
True. That is accurate. But this whole discussion about a knife was something that the police couldn't really substantiate without, they had allegedly taken a knife, but then it was missing from the evidence. And not that they would need to show a knife to the jury, but it was curious, to say the least, that it went missing from the evidence locker. So I would suggest that this was not enough. This did not rise the amount of resistance that these other cases were based on, and that the required findings should have been allowed. If there are no more questions, I'll rest on my brief.
Seeing none, we will hear from the Commonwealth.
Good morning, Your Honors. May it please the Court, Ryan Gigi appearing for the Commonwealth with leave of the Court, and with me is Assistant District Attorney Monica Delatorre. The Commonwealth asks this Court to affirm the defendant's conviction for resisting arrest. The Commonwealth presented sufficient evidence at trial that the defendant attempted to physically break away from arresting officers and resisted arresting officers to the extent that 4 officers were needed to ultimately secure him. Accordingly, Judge Gaziano's denial of the defendant's motion for a required finding of not guilty was proper. As to the lone contested element of the defendant having threatened to use physical force, or create any other means of substantial risk, of bodily harm to arresting officers, I point the Court to 3 separate instances of the defendant using physical force, each of which is independently sufficient to prove resisting arrest. First, on page 106 from May 16th, there is testimony that when he was told he was under arrest, the defendant turned, moved his arms away from the arresting officer and attempted to escape to another street. Second, from page 107 of May 16th, once the defendant had been moved to the ground, there was testimony that he locked his arms under his stomach so that he could not be handcuffed. Third, from pages 107 and 108 from May 16th, there is testimony that the combined efforts of Sergeant Mahoney, the initial arresting officer, and Sergeant Cloakman, the second officer, were insufficient to bring the defendant's hands behind his back in order to secure them. It took the combined efforts of 4 officers to finally place him under arrest.
Mr. Gigi,
If we also consider,
excuse me, can I interrupt you and ask, as to your second incident, how did that, the defendant's lying down and putting his hands under his stomach create a substantial risk to the officers?
It is more a use of force against arrest, which the statute provides 2 separate options, each of which would be sufficient to prove resisting arrest, either use of force, threatened use of force, or creation of a substantial risk of bodily harm. The fact that the defendant locked his arms such that the efforts of 2 police officers could not bring them to his back in order to secure him in handcuffs is a use of force, Your Honor. But if we are to consider the independent but also sufficient avenue of the defendant creating a substantial risk of harm to arresting, a substantial risk of bodily harm to arresting officers, from pages 162 and 163, also page 110 of the transcript from May 16th. There is testimony that the arresting officers found a knife at the defendant's hands, or where his hands had been after he was removed from the ground, and testimony that no officers on the scene dropped a knife. Furthermore, on pages 110 through 111 and 154 of the transcript from May 16th, there is testimony that the defendant was yelling and screaming, as was a bystander who had been with him earlier on, that a crowd was gathering, and that one of the officers, Sergeant Cloakman, was paying attention to the crowd such that to assure that no one in the crowd would intervene with the arrest. From this evidence, it is reasonable to
Would
infer.
yelling and screaming alone be enough for resisting arrest? How is the yelling and screaming? Are you saying that that's creates a substantial risk of bodily injury to the police?
Not the yelling and screaming itself, Your Honor, but the crowd that gathered as a result of the yelling and screaming. There is testimony that the officers were afraid that members of the crowd would intervene in the arrest, and that could create a substantial risk of bodily harm.
I play that out. How?
Well, if the defendant was screaming something to the effect of, calling for help, trying to call an ally from the crowd to push arresting officers off, or somehow separate the arresting officers from the defendant, that could create a substantial risk of bodily harm to the defendant, to the arresting officers, excuse me. Because at that point, the defendant would be free, and some of the facts from cases like Porty may play out. And it is, Your Honors, this is not a necessary or inescapable inference, nor need it be. Under Webster and Beckett, these inferences need only be possible and reasonable. And again, the evidence in this case is viewed in the light most favorable to the Commonwealth.
No, but if you're saying that he, had he not locked his hands and instead, made his hands available to be handcuffed, and otherwise did not take physical actions, if he merely had called out to the crowd and yelled, are you saying that that could be resisting arrest?
It may be, Your Honor, depending on the nature of the crowd and the nature of what he is yelling. But respectfully, those are not the facts of this case. There are 3 separate instances, as I outlined earlier, of force used against arrest, and then at least one other instance of creation of substantial risk with the knife found at his hands.
What about the swallowing? Your brief talks about the swallowing, but I noticed you didn't mention it this morning. If someone you can infer is hiding evidence, is that resisting arrest?
I would not qualify that as resisting arrest, Your Honor. That was in the brief more in order to illustrate that the arresting officers had color of law to arrest the defendant. They believed he was engaged in drug transactions, and the drug transactions themselves are not part of this appeal, Your Honor, but they speak to the fact that officers did have reason in the moment to arrest the defendant. So for the foregoing reasons, the Commonwealth respectfully asks this court to affirm the defendant's conviction for resisting arrest. If the justices have no other questions, the Commonwealth will rest on its brief.
Seeing none, that concludes our hearing of the case. The case is submitted, and congratulations, Mr. Gigi, on what I assume is your first argument, and good luck with graduation.
Yes, Your Honor. Thank you so much.
The case is now being recorded.
Thank you very much. We are back for our third case of the day, 2020 P 1014, Commonwealth versus Mohammed Al-MURAD. And my apologies to anyone if I butchered a name. We are going by our ordinary rules of the appeals court. Each side has 15 minutes, no opportunity for rebuttal. We have read the brief, so we are familiar with both the facts and the arguments. So I would urge each counsel to cut to the chase to the extent possible. And with that, I will turn the floor over to Mr. Rosenberg.
Thank you, Your Honor, and may it please the court. Sam Rosenberg on behalf of Mohammed Al-MURAD. Your Honor, in this case, the jury had to decide whether they believed the child's testimony beyond a reasonable doubt. They had to make that credibility determination. But the prosecutor's improper closing argument prevented the jury from making that decision fairly and from the evidence. First, Your Honor, the prosecutor urged the jury to believe the child's account based on the fact that she displayed sexual knowledge or was able to describe male anatomy to the jury. The problem with this type of argument, Your Honor, is it wasn't supported by the evidence. Namely, the Commonwealth did not exclude all other possible sources of the child's knowledge. This type of argument also, Your Honor, and the SJC points this out in Beaudry, creates a problem where it forces Mr. Al-MURAD to have a positive responsibility or a burden to rebut what a child's sexual knowledge would be.
Well, didn't the victim testify that the defendant's penis felt like a water bottle? And how would a child of this age learn that information from the internet?
I'm not sure it would have to be from the internet, Your Honor, but in the Beaudry case, the SJC said that in order to make this type of argument, the Commonwealth must exclude all other possible sources of knowledge from the record, right? Because it's not in a lay person's knowledge what a child's sexual knowledge would be. And in this case, there was no testimony, expert or otherwise, on what the child's sexual knowledge would be. So I think it's a very tempting inference, Your Honor, but it's not supported by the evidence. And that's precisely why it can be so dangerous, because it could urge the jury to convict because they would make this jump, this assumption, which isn't supported by the evidence here.
Why wasn't the prosecutor's argument geared only toward focusing the jury's attention on the level of detail of the victim's description and not for the purposes that you're describing?
Well, I think if you look at the prosecutor's closing, Your Honor, what the prosecutor said to the jury is, how do we know this happened? Right? So I think that goes beyond the level of detail. And I think the prosecutor even asked the jury, how else would essentially a child describe male anatomy in this way, but for Mr. Al-MURAD's wrongdoing? So I think it went beyond just urging the jury to make an inference from the evidence and to making the argument to the jury that Mr. Al-MURAD must have done this. If not, how would the child have been able to describe male anatomy in this way?
Now, wasn't the child here significantly younger than the child in Beaudry?
Yes, Your Honor.
Doesn't that make a difference?
I don't think it does, Your Honor, because the court in Beaudry is very clear that to make this type of argument, it's necessary that the record excludes all other possible sources of knowledge. And I think if we start to sort of lower the age, maybe the victim was 9 in Beaudry and 7 here, we sort of start to chip away at the Beaudry case. And we also start to engage in that same sort of unsupported inference or assumption that the Beaudry case forbids, because it's just not in the province of the lay person what a child's sexual knowledge would be. That's the province for an expert or something like that, which we didn't have here.
So you're saying that expert testimony would have been admissible, that most 7-year-olds don't know what an adult penis feels like?
I'm not sure, Your Honor. I just know in the Beaudry case, they suggest maybe an expert would be required in some cases. But I don't necessarily know in this case whether an expert would have.
So if the prosecutor had asked, had you ever felt an adult male penis before, and the victim said no, would this closing be permissible?
I don't know, Your Honor. I think it would be closer, but again, the language is very strong that the record must exclude all other possible sources of knowledge. So I think feeling male anatomy may be one source, but there could be other sources like the internet, like television, like a cousin, like an older friend or something like that.
But would those sources provide the kind of description that the child provided in this particular case, as opposed to Beaudry, which was describing sex acts, which maybe is something that could be viewed or described, where you're discussing a tactile experience? Does that matter?
I don't think it does, Your Honor. I think they're both in the province of something that, you know, a layperson maybe wouldn't think a child would know, but could be learned from many different sources. That could have been a description that was passed on to the child or something like that, that comparison to a water bubble.
Does it matter that the defendant was found not guilty of the indictment for victim's hand on his penis?
I think, Your Honor, in this case, the fact that there's a split verdict actually supports the idea that the prosecutor's improper closing influenced the jury. If you look at the cases like Kozak and Granderson, which the Commonwealth cites, where the court pointed to a split verdict and said, okay, maybe there wasn't prejudice, that was dealing simply with inflaming the jurors' sympathies or passions, where the court could say, well, they clearly weren't swept away. But in this case, we're also dealing with an inference not drawn from the evidence. So I think it's more likely that maybe the jury, you know, there wasn't a lot of detail, there was no corroborating evidence, but the jury still felt compelled to convict because they said, well, he must have done something, or else how would the child have this knowledge? So moving on, Your Honors, to the second issue with the prosecutor's closing. Your Honor, the prosecutor suggested in the form of a rhetorical question that Mr. Al-MURAD is a predator. This court has been clear, the courts in this Commonwealth have been clear that the prosecutor cannot use an epithet like predator to describe a defendant, because that inflames the jurors' passions. It could take them away from evidence and inference and into passion and the need to convict him on something. And the Commonwealth tries to justify this by pointing to the evidence in the case. But the Fakey case from last month makes clear that you can't support this type of epithet from pointing to the evidence.
But this
So were
case
you
is not
saying that the
Fakey.
word predator could never be used by a prosecutor in closing, that there'd never be any set of facts that would support it?
No, Your Honor, there is one case from about 20 years ago, the Ormond case, on which the Commonwealth relies. I think reading that case, it sort of stands for the fact that if the Commonwealth's theory is that the defendant, you know, lures or traps an adult victim through permissible conduct, I think he like lured her to his hotel room through a series of sort of, you know, my TV's not working, my phone's not working, that maybe the prosecutor could use the term predator as shorthand for the theory of the case. But here, Your Honor, the prosecutor just meant predator to mean a bad person or someone who preys on children. And I think that makes it a particularly dangerous epithet in this case, because there's a connotation of someone who preys on a child, a predator. We have to do something. We have to get him off the street.
What about the theory that the Commonwealth was arguing that this is a person who took advantage of the quasi-paternal relationship that he had with the child, and that was the source of the predatory, the equivalent of the luring, or an alternative to the luring theory you just described?
Yeah, I think the distinction, Your Honor, would be that in the Ormond case, it was sort of the defendant had to lure an adult victim into a trap of some sort. Whereas here, the Commonwealth was alleging that Mr. Al-MURAD preyed upon the child's vulnerability in some way. I'd say this case is more similar to the Saunders case from 2009 from this court, where it was another child sex case, and the prosecutor described the defendant as swooping down like a vulture. And this court called that impermissible. I think the Commonwealth in this case didn't mean predator to mean sort of the preying, lurking, trapping an adult victim like they meant in Ormond.
So you're saying that predator can never be used if it's a child victim?
I think we have to look really closely when it's used with a child victim, Your Honor, because I think it's an especially dangerous epithet in that context, and I would say it probably shouldn't be used in this context. And moving on to the final problem with the prosecutor's closing argument, Your Honor, the prosecutor, in the same part of the closing argument where she described Mr. Al-MURAD as a predator, she also asked a rhetorical question, namely asked the jury, who would do this thing? Who would bathe with a child in their underwear but a predator? And the problem with this type of argument, Your Honor, is this puts a positive responsibility or shifts the burden to Mr. Al-MURAD to explain or to put forward evidence that someone who maybe allegedly bathes with a child, which he denied, is not necessarily a predator. And it's axiomatic that the burden always stays with the defendant in this case. So that further sort of shifted this burden to not only defend the charges against him, to defend himself against accusations of bathing with a child or being a predator.
I'm afraid I'm having a hard time understanding why you think that makes burden shifting. I understand burden shifting is bad, but I don't understand how the rhetorical question leads to burden shifting.
I think, Your Honor, the idea would be that it makes it so Mr. Al-MURAD has to respond, or it leaves this idea in the juror's mind that, yeah, who would do this? Is he a predator? And it creates this affirmative responsibility, Your Honor.
But why isn't that true of any piece of bad evidence? You know, the Commonwealth points something out and then he feels an opportunity to respond.
Yeah, I believe there's a distinction, Your Honor, between in the Fernandez case from 2018 on which the Commonwealth relies, where the prosecutor just asked why when trying to point to the fact that the defendant had rented a van to show there was some premeditation. I think that kind of question, why in that context, is just urging an inference from the evidence. Here, and also that inference would be an element of the offense. Whereas here, Mr. Al-MURAD wasn't on trial for taking a bath with a child, right? He wasn't on trial for anything like that. So the prosecutor's question in this case sort of takes us away from the elements or inferences and into this province of forcing Mr. Al-MURAD to explain things or rebut charges that he's not on trial for. And finally, Your Honors, the combined effect of all these errors at closing argument was to create a substantial risk of a miscarriage of justice. If we look at cases in both the SJC and this court where courts find substantial risk of miscarriage of justice, they tend to share the same quality as this case. Namely, they're cases that came down to credibility, where there was not other corroborating evidence. In this case, all the jury heard was the child's testimony and the mother's first complaint testimony, which did differ in some respects from the child's testimony. Moreover, Your Honor, there wasn't a clear timeline of events, there weren't dates, there was no real detail, and again, no corroborating evidence. So the prosecutor, by urging the jurors to believe the child because she displayed sexual knowledge, or to put the burden on Mr. Al-MURAD to rebut a child's sexual knowledge or rebut the suggestion that he's a predator, quite likely influenced the jury to convict Mr. Al-MURAD. It was quite likely the thing that put them over the edge from acquittal to conviction. And for that reason, Your Honor, given this lack of evidence and given the fact that it's quite likely that the prosecutor's closing argument likely influenced the jury to convict Mr. Al-MURAD, we'd ask this court to reverse Mr. Al-MURAD's conviction.
Thank you very much, Mr. Rosenberg. We will hear from the Commonwealth.
Good morning, Your Honors. May it please the court, Donna Marie Heron, Assistant District Attorney representing the Commonwealth. The prosecutor's closing argument here, which properly referenced facts and evidence and reasonable inferences therefrom, was proper and did not create a substantial risk of a miscarriage of justice. Referring to the first issue, the Beaudry issue, in Beaudry, the court found that it was an error for the prosecutor to expressly urge in her closing argument that a child's sexual knowledge came from acts of abuse by the defendant. Here, in contrast, viewing the challenge statements in context, the prosecutor is properly urging the jury to convict the defendant based on the victim's credibility in her testimony, and appropriately argued that the victim's demeanor and manner in which she testified, including her description of a male penis, rendered her a credible witness. And I would suggest that makes this different than the Beaudry case. Moreover, the prosecutor didn't cross the line like in the other Beaudry and the other case cited, Diergo, by expressly urging that the victim would not have known about a man putting his penis near her or her rectum unless the defendant had done it to her, which is what happened in Beaudry and Diergo case.
Let me ask this, though, if I could, on the transcript 2, I think on page 15, and I'm not sure this comes up in the defendant's brief, there's a statement, how would a 7-year-old girl even know about this kind of touching or this kind of thing or sexual acts? Isn't that what Beaudry's talking about? And I'm looking at lines 13 through 15.
Okay, I'm sorry, Your Honor.
Sorry, page 15 of the 828 transcript.
Page 15. All right. And yes, what lines, Your Honor?
13 to 15.
All right. Well, to the extent that that did cross the line, Your Honor, I would suggest that it doesn't create a substantial risk of a miscarriage of justice for a variety of reasons. I do think these cases are challenging. I think it's a fine line between what is permissible argument and what is not. To the extent that one does directly cross the line, I would suggest that what Beaudry and Durgo cases found particularly troublesome in that case was that there was the prosecutor was aware or should have been aware there was another source of sexual knowledge from that the victim had of sexual matters. In the Durgo case, the victim had previously been sexually abused. And in the Beaudry case, the victim's sibling, I think, had been previously sexually abused, and it was a topic that was discussed among the family. So the court found that particularly troublesome. In addition, in both those cases, the court also found that the prosecutor expressly urged the jury to believe the victim solely because she testified, which did not occur here, the fact that she solely took the stand. And in addition, I would suggest, as noted before, that the victim's ages were drastically different. She was 7 years old and 8 at the time of trial, while in Beaudry, she was 12, and in Durgery, she was 15 at the time of trial. And also the fact that
Counsel, is that an issue that goes to whether there was error here or the extent of any prejudice caused by the error?
I think it's the extent to the prejudice caused by the error, and what because the court in Beaudry and Durgery found particularly troublesome with the error was these factors, which I don't think are present in this case, given that the prosecutor should have known, or there was another source of the sexual knowledge in both those cases, where there's nothing in this record to suggest there is another source of sexual knowledge.
Well, what do you do with the fact that there's evidence that the victim is taking a bath with her younger brother? And then there's this argument that an 8-year-old girl described to you yesterday what a male penis felt like. It doesn't seem fair for the prosecutor to argue as though this 8-year-old girl wouldn't even know what a penis is.
I think it's
taking baths with her brother.
Yes, but she's talking about how it feels, and there's nothing in the evidence to suggest that she had touched her 8-year-old, her younger brother's penis. And the way she's describing its textured size and its feel, like it feels like a water bottle, I would suggest that part is properly commenting on her testimony at trial. While and any other error would not raise the substantial risk of a miscarriage of justice, particularly where the jury did have a split verdict, which showed that they weren't so swayed by this improper argument that they just convicted on all 3 charges. If there's no further questions on that portion, I'd go to the rhetorical question in the predator. The Armandi case specifically says that as long as it is characteristics of the Commonwealth's theory of the case, that using the term predator is permissible. Here, it clearly was the Commonwealth's theory of the case was that this, as Justice Hand pointed out, that this defendant took advantage of his father-like how he was a father-like to these children, and that he would bathe them, and he took advantage of that situation by having these children play the game and by sexually assaulting the victim. So I would suggest it's a permissible argument. In the case cited by my brother, the term was used repeatedly, while here it was only used once, and then it was couched in terms of the evidence as who would do this, and then she suggested a predator and then laid out the evidence, which was the victim's testimony. So I would suggest there was no propriety, and it was a proper argument to make.
I mean, there are different components to this argument, as I understand it. One is just, it's an epithet that invokes an emotional response and shouldn't be used, but there seems to be another aspect as well, that essentially the prosecutor is improperly suggesting that if you take a bath with a child, you are a predator, you are predisposed to being a predator. How do you address that aspect of this?
I think a reasonable jury would have understood her argument was who bathes in their underwear, which I suggested is not normal for, well, I don't want to say that. I would suggest that her argument was that the defendant took advantage of his position in getting in the bathtub with a victim in just his underwear, and that who does that but a predator would do that, which was her theory and her opening statement, which was this is a case about trust and taking advantage of that trust, which she then tied to her closing argument, which I suggest is proper based on the evidence presented. I don't think it's solely about taking giving children bath, but it's the manner in which he did, and suggesting that the defendant took advantage of the fact that the mother was working, that he was the sole caretaker, and that he took advantage of that by going into the bath and sexually assaulting the victim. And that made him a predator. And again, it was only one time she used the word predator, unlike the case decided by my brother, which they repeatedly used the terms monster, animal, or that was used throughout their argument. So I would suggest there was no substantial risk of a miscarriage of justice. And if any error was cured by the judge's general instructions of that closing arguments aren't evidence, that it shouldn't sway the jury's sympathy. And in regards to the burden shifting, I frankly don't see this as burden shifting at all. And if any strained view of it could suggest it, I would suggest that the judge's numerous instructions to the jury that the Commonwealth always has the burden of proof and the defendant never does would mitigate any potential view of the closing argument like that, which I don't see it as specifically calling the jury's attention for the defendant's failure to testify or failure to call witnesses in a case where the defendant did testify particularly as well. If there is no further questions, the Commonwealth will rest on its brief.
Seeing none, we thank you both very much. The case is submitted.
Thank you.
The case is now being recorded.
Thank you very much and welcome back to the appeals court. I'm Judge Milkey. With me are my colleagues, Judge Hand and Judge Grant. And we are here for the fourth case, which is a DCF case. It's 2020 P 876. I would remind the parties that this matter is impounded. So please refer to the individuals by status. For example, oldest child, youngest child, middle child, or daughter, and so forth. We have read the briefs and are familiar with both the facts and the arguments, so I would urge folks to cut to the chase to the extent possible. And with that, we will turn the floor over first to Mr. Penton.
Thank you, Your Honor, and may it please the court. I am Michael Penton. I represent the appellant father. And as you alluded to, although I make several arguments in my brief, I encourage this court to focus on the two most important things DCF should have done and was required by law to do before seeking a decree terminating my client's rights to his children. The first was to promote regular visitation between father and his children, especially during his incarceration. And second was to make efforts, even special efforts, to meet with father within a reasonable time after filing this petition. In this case, it did neither. And while this court is dealing with the case at hand, there are larger issues that exceed this case when it comes to reasonable efforts, because this is not an uncommon situation for families and it has a rippling effect. DCF's efforts from the inception were in violation of its own regulations and antithetical to its federal and state mandate to use reasonable efforts to strengthen and encourage the family unit before seeking a decree terminating my client's rights.
Counsel, can I interrupt you there? Because I went back to the statute this morning just to refresh my recollection of what the statute actually said on reasonable efforts. And it seems to speak of the need for reasonable efforts before a child is removed, and then thereafter, at least once a year. In this case, when the child was removed, your client was incarcerated. Therefore, the trying to address reasonable efforts at that point seems almost beside the point. It was not possible to prevent taking the child away through reasonable efforts. And then, within a year, we're moving forward with the termination trial. So could you address again what the statute actually says on reasonable efforts and how it applies?
Absolutely. So first and foremost, Judge, the Care and Protection of Wealth and SJC case states that reasonable efforts extends to reunifying the family even after removal. So that reunification effort doesn't end at the removal, it continues through the reunification process. Otherwise, these cases would be tried right out of the gate. So the reasonable efforts that the Commonwealth must use is identifying the family as a problem and dealing with the family and trying to resolve that problem. But secondly, there was a second point to that, I'm sorry. But yes, care and protection of wealth does address that specifically, saying that this is an extension, that this statute extends beyond the removal. And in this particular case, there are things. My client does have limitations, and I'm not pushing that on the department that my client has limitations while he's in prison. Although the social worker did concede during trial that my client was in compliance substantially with the service plan while in prison, and then he engaged in a step-down program, which he graduated with high marks. So he did engage in services as well. So to answer your question, yes, that is exactly something that the Commonwealth has an ongoing duty to the family. But the two things they could have done, which didn't require, even addressing my client's incarcerated status, they could have met with him in a timely fashion, and they could have offered visitations. What is a glaring problem in this case, Your Honor, and I hope the court will indulge me and encourage the court to address, is that there was much to be made about the visitation issue, and it seemed to be overlooked, or at least seemed to be assumed that there was issues with the visitation. But the department has clear regulations that require them to go to court and get a court order and for a judge to make written findings on that issue. And when my client did that, the judge did not address it. He dismissed the AOD and brought it into the trial, which at that point defeats the purpose of even requesting redress for the department's blatant and clear violation of its own regulation. And I do submit to this court.
I have a question on that. When the DCF worker went and visited your client in prison, and he said he did not want to meet his children then because he was on a hunger strike, what should the DCF worker have done?
The DCF worker, that's a great question, Justice Grant. So my client was in a compromised position. He didn't want to see his children because he had lost weight. It wasn't probably a situation he wanted his children to see him in. That isn't a forfeiture of his rights to a visitation. The department, if they had honored and met with him regularly, that they did provide the visit. It was just for timeline purposes. They didn't meet with him for I think 7 or 8 months after he filed his care and protection petition, despite knowing exactly where he was. And there was no impediments to meeting with my client. They testified to that. And then they scheduled a visit, and then they terminated his visits without a court order. And so in some respects, I mean, it's an emboldening position to be in for the department to be able to take these steps in clear violation of their regulations. And then when you seek redress, the court buries it into the trial. When it's too late at that point, it defeats the purpose, it's moot. And so, particularly with the middle child, circumstances have drastically changed for him since the trial ended. And this is a great opportunity for this court to acknowledge that these circumstances are fluid. And when presented with a set of facts that would warrant an investment by this court and by the trial courts to correct a grave injustice, even if the best interest analysis is what's going to drive this case, it certainly is going to drive it for the middle child, because he is in a circumstance that he has no one. And to put it in perspective, just to see that the protectional nature of this case, my client's rights visitations were unilaterally terminated without a court order by the department because the child had a reaction. And there's no science that backed up what the reaction was due to.
Counsel, we understand your arguments on that point, except possibly with respect to the issue of prejudice. How does the visitation issue affect the outcome of this case?
It affects the outcome because these cases are nuanced. I think this court has spoken that the department cannot at some point shut off contact between a parent and a child and then later weaponize that against them, because it does shape the case. And there is an opportunity to right that wrong, at least with the middle child. And this is something that this court should be concerned with going forward, not just with my client, but with other parents and children as well. These are rights of children as well. I'm sure my sister will argue this, that cutting off visitation to punish or for some reason to my client is also a punishment to the children who wanted to see their father and wanted to see him. So there's a lot at stake here, because the department knows this is a very popular statute or regulation. They know better. They know that they need a court order to stop rights. What they bank on is that the parents don't know that. There is every trappings of this case. My client is in prison. He is limited in his access to his attorney. He's limited in his access to the department. The parents should be at least entitled, even in an adversarial proceeding with the government, to rely on the fact that the government is acting in good faith and following the law. And when they're not doing that, to then blame the parent for not acting as swiftly as quickly is very hypocritical. I would point, I know I'm out of time, but
as I said earlier, we're going to be liberal with the clock in this case.
But they're really just 2 points of emphasis, just anecdotal evidence in this case to show how I've got the word, but the first is the department social worker testified that my client was in substantial compliance, with the exception of telling them when he was released on parole. He was released on parole on a Thursday or Friday. He told her in court on a Monday. And the hypocrisy is the department didn't meet with my client for 7 or 8 months after filing the care and protection. So there are examples of that throughout this case, that the onus is pushed on the parent to make some affirmative step when the department is in clear violation of their own regulations. And when the parents, through their counsel, bring that to the court's attention, what does the court do? Nothing for 6 months. And at the time that hearing finally, well, the hearing never took place. So,
counsel, if I can just turn to the issue, you focus to a great extent on the middle child.
yes.
Focusing for the moment on the older child and the youngest child, your client made it clear in his testimony that he wanted what was best for the children. And he even went so far as to say that if they wanted to be adopted, he would not stand in the way. How do you square that statement with your position in this case, where it now seems plain that the children, those 2 children do want to move forward with the adoption?
I square it this way, 2 points to that. That's a great question. The first is, unfortunately, in these cases, sometimes it may be a foregone conclusion by the time it gets before this court. Just case in point, the findings came out a year after the decision. So yes, things happen, and I understand, and I don't concede any ground on that, but I understand your point. But there is an opportunity with the middle child, that there has been a great disturbance in his placement. He went from being adopted by, or potentially adopted by, a family with his siblings to being in a residential program with no hopes. The only real prospect the department sought was an uncle who the child had a very adverse reaction to. He testified, or he mentioned in the department's affidavit, post-motion affidavit, that he had homicidal and suicidal ideations towards this uncle for years. And the department still sought to recruit him as an adoptive resource, which is, again, just another example of weaponizing a bad behavior from my client's son for unknown reasons, and yet ignoring it on the other end because it's convenient to the narrative that they're looking for somebody to adopt this child. And I submit to this court that this is a very child-specific analysis. And so the decision for 1 child or 2 children may not be the right decision for the 3rd child. And so the best interest of the child analysis, when employed in this case, definitely swings the pendulum towards revoking or remanding, at least, or vacating, I should say, the termination decree as to the youngest child. And that would open up the door.
I think you mean the middle child, correct?
The middle child, sorry. And that would open the door then, with the restoration of my client's rights, to visitation. And maybe it might work, maybe it might not work. What was lost in this case, Your Honor, was the opportunity. because the DCF had already decided to terminate my client's rights before it even met with him. And I think that's a very important point for this court to consider.
Okay, counsel, my colleague, Judge Grant, has a question.
Yes.
How does the falling through of the adoption situation for number 2 and number 2's serious psychological issues, how does that change the issue of the termination of parental rights with respect to number 2? Are you arguing that it's okay to terminate rights with respect to 1 and 3, but number 2, because he's more vulnerable, he should be kept not having the parental rights terminated?
No, Your Honor, I'm a realist, if nothing else, and I understand the situations of the 3 children. But legally, there is an opportunity for the court. Well, first of all, before the court makes a decision whether to terminate a parental rights under 210 Section 3, they must consider the plan. And I would concede that the plan for the oldest and the youngest child hasn't changed, but it did for the middle one. And the law is clear that the court can revisit that decision if and then act in the child's best interest. It doesn't have to be subjected to, and I'm sure my colleague and sister will address this more directly, but it doesn't have to be so legal, if that is. I mean, there are the facts, I think, are there, the law is there, and the morality is certainly there. And I think that with the youngest child, excuse me, I say the youngest, but the middle child, and I'm only speaking of, so if I say older, I'm really addressing the middle child. With the middle child, his circumstances are so distinct and different from when the trial ended. And I would submit to this court, it's very convenient or curious that his breakdown happened merely weeks after the trial concluded. So there is case law where the department has told the family to hold it together through trial, and we'll deal with it afterwards. I'm not submitting that that's what happened in this case, but if we add all the things that the department didn't do in the beginning and the prejudgments that they made in this case throughout it, and again, I can't emphasize enough that the decisions against my client were made before it even met with him, and there was decisions made in clear violation of their regulations. And again, the visitation regulation isn't some obscure regulation that knows.
Counsel, I think we're starting to cover the same ground. Unless my colleagues have questions, I think we'll have to move on to the attorney for the middle child.
Thank you. We'll submit the rest of my brief. Appreciate it.
Attorney Russell.
I'm sorry, Your Honor. I'm the attorney for the middle child, Attorney Hamilton Quiros.
My apologies.
Thank you. Sorry. So good morning. May it please the court. My name is Christine Hamilton Quiros. I represent the appellant child, and I'm going to address the issue of post-termination contact because for child, his unwavering desire and need to have contact with his father is what this case is all about. However, the questions of the panel, I would like to address some of those from the perspective of the child. There was a question about efforts while the father was in jail, and the CMR 110 instructs us that when an incarcerated parent has a child in care, the department has to provide special efforts to prevent the permanent separation of that child and that parent. Because our case law also tells us that terminating parent-child contact is so significant, it has a significant impact on whether a parent's rights are terminated or not, whether there is a post-termination contact order or not, and the development of that, the healthy development of that child. And there was also a question about, there was also discussion about the motion. The court waiting to address the AOD motion basically rendered the constitutional questions of DCF's overreach moot, because by that point, the father is being found unfit. And the question about the father refusing visits while he was not eating, that was a matter of a week. There was a visit, and then the department continued to refuse visits after that, despite being asked to do visits. There was also a question about prejudice. How did those?
Counsel, can I just interrupt for a second? You said despite being asked to do visits. I
Yes.
realize there's an affirmative obligation on the department, but in terms of whether or not the father had requested visits specifically after the July 2017 meeting, I don't recall any evidence of that. It seemed to more fall off the radar on both sides.
Well, he had, in the transcripts at 116, 787, 788, it does discuss how father did request visits. He was told that they weren't good for the children by the department and to write letters.
Counsel, the judge seems to have drawn the inference that the July 31st, 2017 visit is what caused your client's psychological decompensation. Are you arguing that he could not have made that without expert testimony?
I'm not arguing that he couldn't make that without expert testimony, because obviously there are facts which could indicate that it was a result of the visit, but not in this case. There was no factual evidence that connected those things, but for time. The judge's finding that that his behavior after the visit was because of the visit was speculative. The judge also found that the child had emotional dysregulation the entire case. And the testimony was, in fact, that after the visit, the child improved. But the judge did not recognize that. So the visit actually helped the child move in a positive direction. However, once the child was told he wasn't getting more visits and his request for further visitation was ignored, he began to again act out. He kicked the seat. He said that he didn't want to go back to the foster home. He started making threats. His behavior actually deteriorated after he was told he wasn't getting more visits. The denial of visits absolutely prejudices the case, because what case law and scientific research about child development tell us is that children need to visit with a parent to maintain their relationship. And in any sort of construction by the department to interfere with that relationship imperils that relationship.
Well, going forward, couldn't your client, whether or not parental rights are terminated, couldn't your client going forward seek visitation at a 29B hearing?
My client, in fact, did ask for visitation. My client asked for monthly visitation after that, and the judge ignored my client's request.
Ignored or denied?
The judge didn't address the request. What the judge did was the judge said, I've read the child's response, and that was it. Not allowing contact during the case precludes my client from presenting evidence to show there is a bond, and a current bond, which is an integral part of determining post-termination contact. The brother testified he was allowed a visit. There was evidence to suggest directly that not allowing my client a visit, not allowing the middle child a visit, and giving the other child, the brother, the visit would negatively impact the child. They fought at visits to talk with father, to interact with father, and yet the judge ignored that evidence and ordered a visit for the older brother and left the middle child out.
But the oldest child's visitation is only once a year. It's your client, I take it, is asking for something of a different order of magnitude.
My client would like monthly visits. He's confused. As his clinician, it's in evidence, his clinician at St. Anne's has said, Case law says that children often need contact with their parent to work through their trauma, their grief, their feelings of guilt, so that they're able to help in a healthy way transition to a new home. My client was never given that opportunity. He more than any other child required consistent contact with father. And if that contact wasn't able to be consistent on father's part, or for whatever reason, he's in a situation now where he can work through those things.
And
Not
counsel, where in the record is that evidence?
That the therapist gave evidence of, it's in R351. It's at finding T90, 680 through 90, I believe. And the therapist actually, there was no clinical evidence which suggested that my client would be harmed by visits. And in fact, to the contrary, the clinician from St. Anne's actually outlined how contact could occur to help the child process his trauma and grief and feelings of guilt.
Now, counsel, you are focusing mainly, at least in the last 5 minutes, on visitation as opposed to the question of termination. Could you address the termination question separately?
Yes, so the termination is different for the middle child than for the other two children.
No, I understand that, but to what extent are you pressing that issue as opposed to focusing on the need for visitation?
The child would like to return to father. His main focus is being able to have monthly contact with father. The record supports that termination wasn't in my client's best interest. He wasn't given a chance to maintain his relationship and work towards getting back home and show the department and the court that contact would indeed help him. But his main focus is being able to continue a relationship with his father. And the child continuing to process trauma and feelings of guilt is also at R236. And in fact, when the department unilaterally made the decision to terminate contact, ignoring constitutional provisions and case law, they did so in a meeting with the workers and corporate management, despite the fact that the child had been working with a therapist for 2 years. They did hear the opinion of the therapist, but that therapist wasn't included in the meeting, and they did not use that therapist's opinion. That therapist did not opine that visits were in the contrary to the child's best interest. And to terminate visits, we know from case law and statute that there needs to be specific findings, clear and convincing evidence that visits are harmful to the child or the public.
So again, are you arguing that the judge didn't have sufficient evidence to find that further visits would be harmful to child number 2, absent expert testimony?
I'm not
Or
arguing.
a psychiatrist or psychologist?
I'm not arguing that that's necessary in every case. I'm arguing that that evidence was available from DCF and DCF did not provide it. And that, taken with the fact that the department unilaterally decided, usurped the court's authority and terminated visitation, contrary to law, to well-established law, should have been considered when the judge was was making its determination whether the father was temporarily unfit, and after finding the father not temporarily unfit, whether or not to issue an order for post-termination contact. The department and then the court continued this pattern of not giving this child a chance to demonstrate that he needed the parent in his life, the only remaining parent. After his mother died, what child is not going to have a bad reaction after the death of their primary parent? his behavior improved after the visit with father, yet they wanted to blame father's visit with the child.
Counsel, when you say improved after the visit, are you talking about during the visit or on the car ride home? Because it was shortly thereafter that he did start to spiral down. And obviously, we understand your arguments about causation and so forth, and that he may have spiraled out of control because of not being able to visit father as opposed to having visited father. But I just want to get the timing right.
Well, the testimony from the worker was that right after the visit in the car ride home, the child's behavior improved. The child requested further visits, and he wasn't given an answer that he would be able to get further visits. And so he started to become upset. He was upset by that. He said he didn't want to go back to the foster home. After the trial and the father's rights were terminated, then the child began to spiral completely out of control and had to be removed from the foster home.
Okay, unless my colleagues have questions, I think we need to move on to the department. Assistant Attorney General Kiernan, the floor is yours.
Thank you. May it please the court. Jennifer Kernan for the Department of Children and Families. Initially, I'd just like to address the issue of the abuse of discretion motion. Father equates the filing of the abuse of discretion motion with almost a guarantee of visits, but that's not the case. In effect, it's as if father succeeded on his abuse of discretion motion, because the court can only order, the lower court rather, can only order the department to comply with its regulations. And when the department filed its motion to suspend visitation, the department did comply with the regulations.
But counsel, putting aside the department's own misstep, didn't the judge misstep by not addressing that issue up front? He said it was sort of folded into the trial, but in reality, it was just taken off the table, wasn't it? Because the issue is, could visitations go forward immediately? And the judge said, we're not going to deal with that. And then the trial took another 6 months. So
the judge did not err. The issue of visitation was addressed throughout the pendency of the trial. There are
no, but the regulation says you cannot terminate visitation unless there's judicial approval and judicial findings. So tell me how the judge didn't err when the judge just said, we're not going to deal with it.
The judge
allowed visitation to stop without making a decision on the issue and without making findings.
Respectfully, the judge did make a decision on the issue and did make findings regarding visitation. I believe their findings about the visit start in 200 to 231. And those findings—
but those findings are about a year and a half after the father filed his motion, correct?
Correct, but that doesn't mean that the judge didn't consider the evidence that was presented at trial when making the determination that visits should not be allowed. So the testimony came out from the social worker, from father. There was testimony from the foster mother, I believe, as well as the foster father, about the reaction that all of the children, but specifically the middle child had after visits, after the one visit with father. That was in July of 2017. And I believe it wasn't until May of 2017 that father actually requested a visit. March of 2017, I believe, was the first time that the social worker—
okay. Now, the burden, I assume, was not on the father to set up these visits.
No, he wouldn't be in a position to set up the visits. But the first time that the social worker brought up the issue of visits was that March 2017 visit at the jail. And that's when father said, no, I don't want to see my children right now.
Isn't that itself a problem, that the first time the issue came up in a discussion between them was over a half a year after the children were removed?
It's not a reversible issue. It ideally, the social worker who was initially assigned to the case would have been meeting with father at jail. I do know that father was habed in for, I believe, one of the initial hearings in June of 2016. Perhaps he had a chance to meet with the social worker at that time. But ideally, yes, the social worker should have been making those visits with father at jail. However, once the new social worker was assigned, that's social worker Fogel, the first time she met with father was that March 2017 visit, I believe. And she brought up the issue of visitations, and that was when father responded negatively. No, I do not want visits with my children right now because he's on the hunger strike. The issue of visits was again brought up in May, and that's when father did ask for a visit, and the visit was scheduled for July. That visit happened, and I'm sure the court's familiar with the description of the car ride there, the description of the children sort of bouncing off the walls in the waiting room, and the car ride home where the middle child, I believe, pulled a clump out of the youngest child's hair, causing the youngest child to bleed. The testimony from the foster mother described sort of the after effects, how the children regressed after that July 2017
How
visit.
do we know that the middle child was regressing as a result of having seen the father, as opposed to having seen the father and being told he couldn't see the father anymore? And at that point, he was affirmatively voicing he didn't want to stay with the foster family, and his mother had just died. It seems to be, without clinical support, drawing an awful lot to say that, oh, therefore, visits should be terminated.
Not necessarily, Your Honor. Before that July 2017 visit, the children hadn't seen their father since November 2015. And after some initial difficulties, once placed in foster care, they did settle down. They had improved in their behavior. So there's a period of time where we have all of the children began to settle into the home, settle into their behaviors. The disruptive behaviors that the foster parent observed in the beginning when the children initially were placed in that home had subsided. It's not until after the visit, after the July 2017 visit, that those behaviors reemerged, and at least with the middle child, even worse, to the point that the middle child was defecating on the floor. That happened twice, I think, 2 consecutive days right after that July 2017 visit. That wasn't something that he had done in the foster home before. Initially, the foster parent reported that the bedwetting had been under control and the night terrors had been under control, but those again resumed after the visits. So there is that causal connection, and especially if we look to the time before visits where the children had settled, their behaviors had settled, and then again to the time after the visits where they seem to regress to their the behaviors where they were initially placed in the foster home, that the foster mother worked so hard to sort of counteract and really get them established. That comparison.
Okay, counsel, time is getting short. Let's talk about the middle child.
Yes.
When the father's 60B equivalent motion came up, the judge effectively said, oh, well, you know, it's not unusual for adoptions to fall apart. This is not a big deal. This is a situation where the foster parents understandably said, okay, we can't handle the middle child any longer. The middle child's situation has dramatically changed. Under these circumstances, please explain to us why it makes sense to terminate the father's rights and not to allow visitation.
And I see my time has expired. If I may continue.
You may continue.
Thank you. First, it wasn't exactly a surprise that the child's adoption disrupted. Father's own brief details, at the time, the judge issued his decision, the child was being appointed a guardian ad litem for antipsychotic medication. So it's not as if all of a sudden, after termination, the child completely deregulated or dysregulated to the point that he needed to be hospitalized. This, unfortunately, was somewhat foreshadowed due to the hospitalizations that the child had during the pendency of the case, especially after the hospitalizations didn't happen until after the visit
But
was
I hear what you're saying on the facts, but doesn't that in some ways make the situation worse? In that when the trial ended, everyone was aware of the middle child's issues, but the bottom line was the foster family was still planning to adopt him. That's what dramatically changed. And so the question then is, why under those circumstances terminate the father's rights, even if he is not currently fit to assume direct custodial parental responsibilities?
The fact that the foster parents had decided that they can no longer, or have decided that they can no longer care or be that adoptive resource for the child doesn't negate the fact that father is unfit and that it would not be in the best interest of the child to reverse the termination. Evidence came out during the trial that father repeatedly physically abused the children, hitting them with a belt, a Hot Wheels racetrack that he called the whipper. He forced the children to take cold showers. So the fact alone that the pre-adoptive family had withdrawn does not negate father's history of essentially not parenting the child, and when he was parenting the child, beating the children.
Okay, assume arguendo that the middle child is unadoptable at this point. Why terminate?
Termination is in the best interest because just because the child does not have other options at this point, or assuming in arguendo, does not make father the best option. It doesn't change the fact that father has a significant substance abuse history, has a history of physical abuse, has a history or rather pattern of unavailability. Even when he wasn't incarcerated, he really never parented the children. And even at the time of trial, he testified that he didn't know when their birthdays were. He did not know what grades.
Okay, assume arguendo that the middle child for whom the department has custody stays in institutional care for the indefinite future. So he is not in the custody of the father. Why terminate?
The department, even if it is residential care, the department can provide services that father would not be able to do. The department can provide supports that father has basically proven throughout his history of not parenting and being incarcerated, that he cannot be a support for this child. And this child needs a support, and the residential setting can be that support. And even later, as the child ages, the department may, and forgive me, this is going outside the record a little bit, but the department is able to change the goal for the child rather. And if it gets to a point where the child is moving into his teenage years, the department can then change the goal to alternative plan permanency living arrangement, which is a specific plan that is sort of designed to help teenagers, help children sort of move in towards adulthood. And the department arguably is in a better position to help support that child now and into his transition through adulthood.
How does the termination of the father's rights affect the department's authority to go down that path?
Well, if father's rights are not terminated, then the department is sort of, or rather, I see what you're
custody.
saying. Yeah, I see what you're saying. There's custody, but it's an issue of permanency and best interest in the child. There is the option of adoption that is still on the table. And without termination of parental rights, we cannot look for families to adopt this child. If the department merely has custody, we're at a disadvantage in matching families with the child. Without termination of parental rights, father could bring this case back into court again and again and again, disrupting any potential permanency that the department may be able to establish for this child.
Okay, unless Judge Grant.
This is kind of building on some of Judge Milkey's questions. On the 60B motion, the judge essentially ruled that the child number 2 needs permanency and to that this child's allowing visitation now would cause more problems to the child. Could the judge make that decision without expert testimony from a care provider of the child? And do we know from the record any reason why any such testimony was not provided either at trial or in connection with the motion?
First, I don't necessarily believe that expert testimony is required. And second, I don't believe there's evidence or any indication in the record as to why expert testimony was not provided. I do know that in response to the 60B motion, I believe the department submitted an affidavit that included feedback from the middle child's providers at St. Anne's. So there was that information that the judge had before him to make that decision. And I think the statute says that the 60B, it's applicable when, if it's within, the motion is filed within a reasonable amount of time, and if prospective application is inequitable, and that's not the case here. First, father's 60B motion was not filed within a reasonable amount of time. It was filed 19 months after the decree and over a year after the adoption disruption. And also this court—
So it was on the same time track as the judge's findings.
Unfortunately, ideally the findings would have been issued a bit sooner, but that doesn't change the fact that the decision terminating parental rights was the 60B motion was filed 19 months after that. A significant amount of time had passed, so the time frame with which father was filing was not reasonable, and the disruption of adoption is not considered an extraordinary circumstance for which 60B should be allowed, and that's according to Jillian and Mark. And basically for those reasons, the trial judge did not err in denying father's 60B motion.
Speaking hypothetically, I guess, are there therapeutic reasons why DCF might not seek to introduce testimony of a child's care provider? And here they seem to have just relied on testimony of the ongoing worker and the testimony of the foster parents to draw the nexus between the July 2017 visit and number 2's decompensation. So are there therapeutic reasons why they might not have used the privilege?
Well, I think our ability to pierce that privilege was not established. We would first have, if we were going to seek to introduce expert testimony rather, but the child's therapist, have him or her testify. We need to get a guardian ad litem appointed. The guardian ad litem would probably take some time to meet with the child, meet with the therapist, and then render an opinion as to whether or not that privilege should be waived. And that in itself is a rather time-consuming process. So without that, the department wouldn't necessarily have been in a position to present testimony from the child's therapist.
Okay, do either of my colleagues have any further questions? Thank you very much. We will hear now, finally, from Attorney Russell.
Good morning. May it please the court. Morgan Russell on behalf of the 2 appellee children, the oldest child and the youngest child. And I understand that father may be conceding. It's a little bit unclear the judgment of termination, the rights of my two clients, but just in case any of the issues father did present.
Just if I can, counsel, if I could just address that. I did not hear the father concede that. I heard the father make an expression of realism, or the counsel.
Realism. Okay. Well, just
So you should assume that he did not concede.
okay. So
the
he
point,
may not have conceded, but I do want to address it just in case. So first is the issue regarding the finding of reasonable efforts by the department. Father points out, or argues rather, that the court is silent on that in their findings. I would suggest otherwise. There are two specific findings that the tasks presented to father were appropriate and necessary to address father's parenting deficiencies. And during father's argument this morning, he did actually identify reasonable efforts as identifying the problem and then dealing with that problem. The court found that explicitly twice in her findings, at finding of fact 185, as well as finding of fact 191, and at her conclusion of his conclusion of law 32, section 4. So I would say that there was no error on that account, at least. And even if the facts, or this panel finds that the facts do not support that finding of reasonable efforts, that still does not preclude the court ordering termination in the best interest of the children. And that is statutorily stated in 119, section 29C. To move on to the visitation issue, I would also want to point out that there is no nexus between the lack of visitation and father's continued unfitness at the time of trial, or the likelihood of his continued unfitness. Father presented no evidence that had these visits been allowed, that somehow that would have affected his ability to parent these children in the reasonable, foreseeable future.
Counsel, how about on the issue of visitation? One of your clients got visitation, mandatory visitation once a year. The other did not get any mandatory visitation. As you know, one of the main issues going into the visitation decision is whether or not there is a strong bond. Here, the father has seen the kids once over years, and that was in part because of the agency's decision to terminate those visitations. So why isn't that nexus there fairly directly?
In regards to the post-visit, the post-termination and post-adoption visits, I would submit that just because the department may have possibly created this barrier, and again, there's little to no evidence that father wanted visits anyway. The court does find that even without the visits, father only sent a total of 3 letters to his children. One was inappropriate anyway. So there's all of 2 letters from father to these children.
I think there were 4. 1 was inappropriate. 3 went to them.
Possibly 3 or 4. You're right. But that doesn't, strike that. There was no substantial bond relationship at the time. So it's not as if this child was seeing her father regularly, was used to having father around, and then all of a sudden DCF becomes involved and she's cut off from her father. That's not the case here. There's ample evidence in the record that, first of all, father had moved out of the home when the youngest child was only 3 years old. When he was still in a relationship with mother, his presence in the home was sporadic. The oldest child testified that there were plenty of times when father was out of the home. He'd be gone for a week at a time. He was not present. He was not the primary caretaker of the children. He was not involved with schooling, doctor's appointments, dentist appointments. He did not, eat dinner with the children, did not put them to bed. And this is all just before she's even 3 years old. Now, father is then incarcerated when the youngest child is 5 years old. There's a period of maybe 6 months where mom is sporadically visiting father. First it's weekly, then it's, it doesn't really say, but then it kind of lessens over time to the last visit in November of 2015. At that point, my client is only just 5 years old, or maybe just turned 6. So she's still very young, and now she's a 6-year-old who barely saw her father prior to all of this happening. And now she's in DCF custody, and admittedly, the department should have been offering visits, maybe, but it's kind of par for the course for this child at this point. It's not as if she was used to seeing her father and all of a sudden she's like, what's going on? I don't understand this. There's that one visit. She dysregulates after the visit as well. And yes, there's a question as to how this occurred. But I will say that there was testimony from the foster father that the children would, talk about father, sometimes every once in a while, talk about father. And then after the visits, that those conversations stop, unless they're expressly asked something about father. So that wasn't as if the children are still sitting there saying, well, where's father? I want to see dad. It's this visit happened. They didn't feel good about it. They didn't want to talk about it anymore. So ignoring whatever may be happening with the middle child, with the youngest child, there is no bond there. And the judge does find that, and he found that correctly. And so post-termination visits are not necessary there, and the judge was proper in not ordering the same. You have this pre-adoptive family who is bonded to these children, who's with these children, emotionally supports these children, who's in the best position to make the determination, if the youngest child does change her mind in the future, to allow a visit if that is what the child wants and if it's in her best interest. And I think it was proper for the court to leave it to the pre-adoptive parents with respect to the youngest child. That may cover everything. I don't know if the court wants to hear any argument about the likelihood of the unfitness continuing. There's clearly no issue about his unfitness at the time of trial. I would just say that his actions during the pendency of the trial up through the end, where he missed 2 trial dates, I believe, and had, was homeless, although he had been receiving these services in a residential program, he still made the conscious decision to leave the program, admitting, well, I could go back if I wanted to and, obtain these services that DCF is requiring of me to possibly be reunified with my children, but choosing to.
Well, now that you've raised the subject, how do you address the fact that when the father was incarcerated the last time, he did do some job training, and when he came out of the step down program, he did start a new part-time job, and there was testimony that the job was going to increase in hours. And as he admitted freely at trial, his job before he was incarcerated was as drug dealer. So at least there is some evidence that the father was turning his life around. And then fast forward to the 60B, there was other evidence which the judge dismissed merely by saying it was self-serving. But there was evidence that he was in a relationship, that he had more stable housing, and so forth. So why isn't there at least some reason to doubt the conclusion that the unfitness would last forever?
Well, to address first, any post-trial progress on behalf of father has no bearing on the judge's finding at the time of trial. Again, this is a small snapshot. Yes, father has done well. He's done his programs. He may have a new job, but throughout the entirety of trial, he's still showing a complete lack of insight into how his behaviors prior to the trial, prior to the children's most recent removal, negatively affect the children. He's still saying, well, it's all mom's fault. It's not my fault. Oh, well, I had to be a drug dealer because I had to support my family. He's not acknowledging that he needed to improve as a parent. He wasn't acknowledging it through trial. And then to make the decision to be homeless while the trial is still pending only shows that could happen, that would continue. The judge had no reason to know that a year later he would have stable housing and be in this relationship. So that shouldn't have any effect on the decision that the judge made at the time of trial in 2018, August 2018, that father's unfitness was likely to continue to a near certitude.
Okay, Judge Grant.
Quick question. I noticed that the judge pointed out that the father missed the 2 days of trial toward the end, and one of them was the day on which your client, the oldest child, testified, and the other was closings. Do we know anything from the record? There was conversation at the beginning of the day that your client testified about whether it would be problematic for him to do so with his father there. Do we know anything from the record about why the father was absent that day, or if we can really hold it against him?
I don't recall there being any express reasoning as, because this child is testifying, that's why father isn't there. Admittedly, it was probably better for my client that father was not there, but I don't know that that was the reason that he did not show up. I don't believe, I think it was maybe like, I don't know.
Thank you.
Okay. Do either of my colleagues have any follow-up questions? Hearing none, the matter is submitted. I do want to just say one more thing, though, and that is this case raises very complicated, interesting questions, which we will do our best to resolve and to do so expeditiously. I do note that somewhat buried in the transcript of the trial and the aftermath, there is a reference to at one point the parties were discussing a settlement. It strikes me that as DCF cases go, this case might actually be appropriate for a settlement. And without going into territory I should not, I'll just say that it is easy to imagine a result that could be achieved by settlement that might well be better than any result you get from the three of us. So as we do our job in terms of bringing this appeal to closure, we would encourage the parties, if they are so inclined, to explore the idea of a settlement of the issues. And with that, I will just say that the matter has been submitted. And thank you all very much for handling these difficult issues, both well and with sensitivity. Thank you.
Thank you.
Case is now being recorded.
Thank you very much, and welcome back to the Appeals Court for our fifth case of the day. This is 2020 P899, Philip Mazzola versus Bonita O'Brien and another. I want to remind the parties that we have read the brief, so we are familiar with both the facts and the legal arguments. So to the extent possible, I would urge counsel to cut to the chase. And with that, I will turn the floor over to Mr. Sheehan.
May it please the court, William Sheehan for the plaintiff, Philip Mazzola, trustee of 17 Wingashiek Realty Trust. With me, although off camera, is Tom Flanagan, co-counsel. The defendants O'Briens have an express easement, quote, to pass and repass to and from the beach area, end quote, of Coffin's Beach, over a strip of land 15 feet wide and 450 feet long, located on the property of the plaintiff Mazzola. The O'Briens have operated an ATV, an all-terrain vehicle, on that easement, which the plaintiff contends constitutes an overburdening of the easement because it is a use beyond the scope of the easement. Two issues are presented by the appeal. The first is, does the easement permit the operation of motor vehicles on that strip of land? And secondly, even if it does, is ATV use prohibited from the easement by reason of General Laws, Chapter 90B, Section 26E? Addressing the statutory issue, since 2010, the legislature has allowed the operation of ATVs on private property in only 4 instances. If you are the owner of the property, you may do so. If you are the lessee of the property, you may do so. If the land has been posted for such use, you may do so, posted by the owner. Or if the operator possesses a document signed by the owner or lessee of the property, quote, authorizing the operation of such a vehicle.
I have a question, counsel. In the language of 26E, does owner or lessee mean an owner in fee simple, or does it also mean somebody with rights under an easement to the property?
I would suggest it means an owner in fee. And the reason I would say that is that there is no suggestion in the statute that merely having an easement is sufficient to come within the statute. It is stipulated in this case that the O'Briens do not have a document from the plaintiff specifically conveying written permission to drive an ATV. And so the only way that the O'Briens can be said to have the ability to do so is if their so-called, what I'll call a general use document, that is the easement, gives them the right to do so.
Well, counsel, when the statute was enacted, it was already, of course, illegal to trespass on someone else's land. So with that in mind, wasn't the purpose of the statute to make it easier for law enforcement officials to manage and enforce trespass laws, so that in the field they could easily determine, because the person didn't have their piece of paper, that they were trespassing? And the statute also in a different section allowed a ticketing and fine. So I mean, wasn't this really, again, a trespass related statute?
I don't think it was simply that, Your Honor. It was also a recognition in adding ATVs to snowmobiles that there was something obnoxious, if not unsafe, about this operation. And so there is a limitation to those 4 instances when one can use private property for ATV use. And I think what's instructive here, as we look at whether or not the use is authorized under the second exception, if you will, that is 90B 26E II, is a general use document sufficient, or do you need a document that specifically talks?
But counsel, why, returning to Judge Grant's question, if the purpose of the statute is to enforce trespass laws, why wouldn't the holder of an easement, assuming that the easement includes the right to pass and repass on an ATV, why, for these purposes, wouldn't that person be considered an owner, so that the statutory requirement that they have this extra ready piece of paper would not apply?
Well, an easement is not ownership of property. In fact, it's quite inconsistent with ownership of property. It's the ability to use the property of another. If
an easement is a property interest, correct?
It's a property interest.
So he is an owner of a property interest, correct?
He is the owner of a property interest. However, when you look at the language that talks of, in part 1, if you will, both of an owner or a lessee, what I suggest becomes evident there is that the notion of having just the general right to possess, to use property is insufficient because of the word lessee that's found in the first exception, if you will. The reason I say that is this: if all that one needed to use an ATV on private property was a document or a right, such as a lease, to have that general use of the ability to use that property, then you would not see the word lessee in part 1 of 26E, because it would be surplusage. If all that was needed was a general use document, any lease would be a general use document. And so there would be no reason to have the word lessee in part 1, but lessee does appear in part 1, and it shouldn't be treated as surplusage. And when you look at the language of part 2, you will see that there is language that talks about this particular use being authorized, the authorization of such a vehicle being used. So
Isn't that I'm sorry, I didn't interrupt you. Go ahead.
For those reasons, consistent with general principles of statutory construction, I would suggest that the court below erred in saying that all we need is some kind of a general use document. There was also not.
Counsel, in a footnote in your brief, you point to a separate regulation that says in any event, you can't ride an ATV within 150 feet of a residence without the owner's express permission. Was that argument, I'm trying to figure out why that argument is relegated to a footnote. Was this point raised in the court below?
It was raised in the court below. I would suggest respectfully that it probably rises and falls on the same notion, that is, does an easement, does a general use document, does that satisfy the purpose of the statute or the requirement of the statute? Also, would it satisfy the requirement of the regulation? We argued both of those instances, Judge. Judge, moving to the issue of the second issue, that is the more general question presented by the appeal. And that is, does the easement permit the operation of motor vehicles on the 15 by 450 foot strip of land? To answer that question, we have to do the following. First, we have to identify the instruments creating the easement. We then have to look at the language of the easement, which is the primary source to determine its meaning. Then determine the intent of the parties as gleaned from that language. Look at the circumstances at the time of creation, resolving any doubt in favor of the servient owner. The first error that the court made below was saying, and you'll see it at appendix, at page 112 of the appendix, the court focused on a deed of 1960 into the Ericksons. That's not the deed that is at issue in this case. There are two instruments that the court must look at in order to answer the questions here. And the first is the deed from Erickson, who was the common grantor, to Hosmer. And in that deed, and that's found at page 33 of the record, in that deed, two easements were reserved. The first, 15 by 450 foot right-of-way to pass and repass to and from the beach area. The second was a right to use the area between mean high water and the bank for beach purposes, including what the lower court found important, the mooring of boats. The second instrument that must be studied to answer these questions is found at page 51 of the appendix. That is the deed from the common grantor Erickson to Siskind, Siskind being the predecessor in title to O'Brien. What's important in that deed is what was granted to Siskind, because Siskind can only pass on what he received. And what Siskind received from Erickson was the first of those two easements. That is the right to pass and repass over the 15 by 450 foot wide strip. Erickson reserved the right to use the area between bank and mean high water mark, but did not grant it to Siskind when he conveyed some of his land to Siskind. In fact, he continued to reserve the right to use that area for successors, but he did not grant it to Siskin. This is very important because.
But counsel, just focusing on the perpendicular right of way.
Yes.
Why doesn't the right to pass and repass include within it the right to use reasonable means available to pass and repass?
There's no suggestion, unlike in the cases that we cited, Martin and Hodgkins, there's no suggestion in the language to pass and repass that it extends to motor vehicles. In fact, all it says is you have the right to pass and repass to get to the mean high water mark. But there's no. Are you familiar with the Kubik case from last year in this court? I apologize. No, I'm not, Judge. I apologize.
Yeah, you may want to take a look at it.
So we talk about that language, not talking of any or hinting at motor vehicle use. We also focus on what the court concluded was the reason that there should be an interpretation of that easement so as to allow motor vehicle use. But the lower court conflated the two easements. The second easement, which is what the court relied on, that is, well, if one can moor a boat in that area, then vehicular use should be implied. But that right was not granted to O'Brien because it was not granted to his predecessor, Siskin. And so what the lower court did was look at what had been reserved by Erickson and treated it as if it had been granted by Erickson to Siskin. And that is the primary error that the court made below in interpreting that easement. There was no evidence that when you start looking at the circumstances that were in existence at the time that easement was created in 1963, there was no evidence at all that motor vehicles were commonly used or used at all to get over the sand to the water. The court said, well, it was commonplace in 1963 that was so, but there was no evidence of that. In fact, the court said that there was scant evidence, that was its word, scant evidence of any motor vehicle use before 1994. And all of that use is detailed in the record.
Counsel, I think one of my colleagues has a question.
I have a question about the difference between the statute and the regulations. I noticed that the statute 26E talks about private property, but the regulation, the one about the distance from residences, talks about within 150 feet of an occupied residence. Does that mean that the O'Briens are not violating that 150 feet regulation if the Mazzolas aren't home?
I think that's too strict a reading. I think when you're talking about an occupied residence, I take it that would be in so as to be distinct from a building or something that's not being used whatsoever. I don't think it is particularly important insofar as trying to interpret that regulation as to whether the Mazzolas happen to be in the house at the time or whether they've gone out for lunch or something like that. I don't see that as what that regulation is aimed at.
Thank you.
Counsel, unless my colleagues have follow-up questions. Hearing none, we will hear from Ms. Fine.
Thank you, Your Honor. May it please the court. My name is Meredith Fine. I represent the appellees, John and Bonita O'Brien. What Mr. Mazzola is asking you to do here is to make a major change in the law of easements in Massachusetts. If we extend his argument, part of his argument is that an easement must enumerate every single possible use that to which the easement can be put, which, among other problems, would be an incredible drafting. I don't know how you can even draft an easement that would enumerate every single use that could be made of an easement now or in the future. So that's problem number one. Problem number two, if the court accepts their argument about the statute, it would overturn, as the trial court said, countless statutes across the Commonwealth, not just for people using recreational vehicles to beaches, but also people using them in the woods, and possibly even police who use them on beaches as well. So Mr. Mazzola is asking you to make, to turn the law of easements on its head. The interpretation of the scope of an easement is a question of fact that can only be overturned if it's clearly erroneous. The two cases that Mr. Mazzola cites in his brief for the argument that interpretation of easements is a matter of law, both have to do with the court closely reading the texts within the four corners of the easement, and don't have anything to do with the scope, the use of the easement. LaBounty versus Vickers, Duty versus Spur, Stack versus D'Ambrosio, Westchester Associates, Chatham Foundation, just a long list of cases say that the judicial interpretation of the use of an easement is a question of fact. The Cubic case is, as Justice Milkey says, is exactly on point.
So why didn't you cite it in your brief?
Why didn't I? I should have. When I found it, I was slapping my forehead. The color of the Cubic case aside, that's a case that's right on point. That was an easement that only discussed foot traffic on a right-of-way to a lake or a great pond. And the court said that the reasonable use of that easement also included motor vehicles, in part so that it can include boats, use of boats. So, and in that case, the court used the clearly erroneous standard that applies to questions of fact. The foundational deed here is the deed from Erickson to Hosmer that is now the Mazzola property. So Mr. Mazzola knew what he was buying, presumably, and that deed included rights to the 11 other property owners for maximum use of the beach with maximum access to the beach. The language about the right-of-way creates a right-of-way that's 450 feet long and 15 feet wide. That's not a path, that's almost a road. And it contemplates more than pedestrian traffic. And that's what the court found. And I know that Mr. Mazzola wants you to think in his brief and today that this is a limited easement that expanded over time to include vehicles. And that's not true. The court credited the testimony of a neighbor who lived there since the 60s, saying that people have driven recreational vehicles over that easement since it was created. And two, that there's nothing wrong with driving an ATV over sand, over a beach. There was no testimony whatsoever, certainly no expert testimony, that the O'Brien's use of ATVs over that easement damaged the easement.
Counsel, I think we understand your arguments on the property aspects of this case. Could we turn to the statute and regulations?
Yes, sir. So the statute, as Your Honor said, applies to trespassers. The reason it even mentions lessees is that it's aimed at protecting occupants of the property from trespassers. The only three cases that arise out of this section of the chapter have to do with tort liability and whether there's insurance coverage for recreational vehicle accidents. Those are the only cases that apply to this section, because that's what this section is about, trespassing and tort liability. If the legislature intended for this statute to apply to easements, it would have said so, it could have said so, and it should have said so. And it didn't. And so this
Well,
statute,
except counsel, I mean, the statute says what it says. And it says that, you know, you can't use an ATV on private property unless, and then it creates some exceptions. And just starting with the issue of what you call retroactivity, just speaking only for myself, I'm having a hard time seeing how you're saying that this statute is retroactive when it regulates activity that occurs after the statute was enacted.
well, I don't believe the statute is retroactive, certainly to the O'Brien easement. And if a statute
No,
is
you're saying that the plaintiff here is trying to argue that it's retroactive. And I'm saying under his interpretation, the statute either applies or it doesn't. And if it applies, it's either satisfied or it doesn't. But I'm having a hard time seeing how their interpretation makes it retroactive, where it doesn't regulate activity that occurred prior to the statute. It's just saying from now on, you can't do this unless.
The problem here is that if this statute applies to easements, what it's saying is that every time the servient estate gets a new owner, you have to go to that owner and get fresh written permission every time. And that would make easements all over the Commonwealth absolutely worthless. That is not what this statute was intended to do. The statute is confined to its clear language. So it's what you're saying, that it should have applied to the O'Briens from 2010 on?
First of all, I'm not saying anything. I'm saying that you are saying that the statute was not intended to be retroactive. I'm having a hard time seeing how you are claiming that the other side is arguing that it is retroactive, where the statute merely regulates conduct that occurs after the statute was enacted. You can argue that it doesn't apply, or that if it does apply, it was satisfied, but I'm having a hard time understanding your retroactivity point.
Either the easement counts as a writing or it doesn't. And the trial court ruled that it does apply as a writing. And so number one, my argument is that the statute doesn't apply to this easement at all. Number two, even if it does apply, we have the writing that it requires. And number three, if you take Mr. Mazzola's argument, it would overturn every easement that people use all over the Commonwealth. It's not.
Counsel, could we turn to the regulation as distinct from the statute? Because the statute appears to give the agency somewhat plenary authority to adopt regulations. In its wisdom, the agency has decided that one cannot ride an ATV within 150 feet of an occupied residence unless you have written permission.
Right.
That's not key to ownership, so that you can imagine easily a configuration where someone was attempting to ride an ATV on his own property that happened to be within 150 feet of an occupied residency. If so, the regulation on its face would appear to ban that as a police power regulation absent permission. why doesn't this regulation, independent of the statute, independent of the property issues, simply prohibit the conduct that your client would like to do?
Because we have the written permission already. The easement is written permission to every owner of these 11 properties to use that easement, even though it is closer to the MAZZOLA property than 150 feet. We have the written permission. Because to rule otherwise, as I say, would just overturn easements all over the Commonwealth.
I'm having a hard time understanding that. This is a police power regulation that says, from now on, you can't do this unless you have written permission. And if the ATV owner was on his own property, he doesn't need permission to use that land, but it still would be prohibited conduct under the regulation unless he gets approval. So the regulation seems divorced from the property law issues.
I at the risk of being repetitive, we have the permission. So Mr. Mazzola lived with people driving over this easement for 20 years without complaint. Now, suddenly, he wants to make a major change in the easement laws because, as the court found, he has 12 minutes of discomfort a couple of times a week. This would deprive people all over the Commonwealth of their longtime easement rights. It would deprive the O'Briens of easement rights that they have used responsibly for decades. And it would be especially cruel to Mrs. O'Brien, who has no other way of getting to the beach. The judge's decision was well-reasoned. It was based on fact and on the record. And there's no reason to overturn it.
I don't remember the judge dealing with this 150-foot regulation, do you?
It was not hotly contested during the trial because the court was focused on facts and the scope of the easement. Because everything comes from the scope of the easement. If the scope includes vehicles, which it certainly does, then the statutory argument goes away. And the issue that my brother raises about this so-called hole in the title was never raised at trial, never raised in the complaint. Why even have the right of way if you can't use the beach for all the purposes, all the reasonable purposes to which it was intended? And the laws are clear that when you have a general easement such as this, that gives a right to pass and repass, it includes all the reasonable uses that come with that. And I just want to say that the deed into Mr. O'Brien's predecessor, the deed that my brother is talking about was a quitclaim deed. And it conveyed all of the ownership that Siskin had. Whether the deed said it or not, that's what a quitclaim deed does. It conveys all of your right, interest, and title to the grantee. And that's what Siskin did here.
Counsel, one of my colleagues has a question.
Does in his possession in the statute and the regs mean that John O'Brien Jr. has to have a copy of the deed with him on the ATV? And if not, doesn't that cut against Judge Milkey's point earlier that this is mainly for the purposes of law enforcement being able to enforce trespass in the moment?
So I'm sorry, are you saying that people with easement rights should be carrying them with them?
Well, under this statute, it says, I understand you've argued that that he has permission under the deed, that he's an owner under the deed And I'm trying to find my copy of the statute right now, and I'm having trouble flipping to it. Okay. So does possession within the meaning of 26E, does that mean on his person? Or is it enough that it's in his possession back at the house or in his safe deposit box?
I would describe,
Go ahead.
I would describe that as in his legal possession.
Thank you.
Okay, do either of my colleagues have any questions? Hearing none, thank you both very much. Interesting little case. And
Case is now being recorded.
thank you very much. We are here for the sixth and last case of the day. It is 2019 P1758 Macy's Retail Holdings, Inc. versus Board of Assessors of the Town of Burlington. I would remind the parties that we have read the briefs, so we are familiar both with the facts and with the legal arguments. So in light of that, I would urge each side to the extent possible, cut to the chase. And with that, I will turn it over to Mr. Costa for the Board of Assessors of Burlington.
Thank you, Your Honor. Good afternoon, members of the panel, and may it please the court. Again, my name is Adam Costa. I represent the town of Burlington and its Board of Assessors, the defendant before the Appellate Tax Board, and now in these proceedings, the appellant before this court. Your Honors, as you know, having reviewed the briefs, the case before you involves the Macy's department store at the Burlington Mall in Burlington, Massachusetts. But more than that, it involves the entirety of the site that is owned by the party to these proceedings, Macy's Retail Holdings, which includes not only the Macy's store itself, but much of the property that surrounds the building. Before the Appellate Tax Board, the parties each produced their respective appraisers who offered a variety of testimony concerning things like market rents and vacancy rates, expenses, and so on. And the Appellate Tax Board, after hearing that evidence, chose from among those various factors and determined the fair cash value for the 3 fiscal years at issue of the Macy's property. And I think what's important, and again, you know this if you've reviewed the briefs already, but what's important is that the Board of Assessors is not challenging much of that determination, much of the decision of the Appellate Tax Board. The sole issue that has been brought before this court, this panel, is one aspect of that decision, and it's specifically this concept of pad sites on the Macy's property. These pad sites, in essence, are development sites that are adjacent to a retail shopping center. They exist not just at the Burlington Mall, but all over Massachusetts and the country. These pad sites provide opportunities for freestanding retail operations, for restaurants and things of that sort. In 2015, Macy's had submitted a concept plan to the town of Burlington for the potential development of 3 pad sites at the Macy's property in what is now the parking lot adjacent to the Macy's retail building. That concept plan never progressed any further, but when these cases came before the Appellate Tax Board, the appraiser that provided testimony on behalf of the Board of Assessors included a value for one of those 3 pad sites. And the Appellate Tax Board determined that that was improper and determined that no value should have been assessed to a potential pad site and excluded.
Counsel.
Yes.
This case, to a great extent, comes down to a classic battle of the experts on how to evaluate the pad site issue. The ATB is the fact finder in this case, and it accepted the view of Macy's expert. Why doesn't that essentially end the case?
Your Honor, I think it for 2 reasons. I think the first is I appreciate that factual errors are very difficult to reverse or overturn on appeal, that the The clearly erroneous standard makes it so. With that having been said, there needs to be sufficient evidence that was presented to the lower court, or in this case, the appellate tax board, that the board relied upon in adjudicating the case and arriving at its final decision. And I think it's notable that, as you say, this was a battle of the experts, and that may have been appropriate with respect to determining appropriate market rents or vacancy rates or expenses. Those battles of the experts are typical before the appellate tax board. But where the issue here was the potential developability, I cite in my brief, and I believe that my sister cites in her brief, to this standard that a property's highest and best use must be legally permissible and physically possible. That sort of a determination is not the kind of determination that appraisers are experts at making. That determination requires due diligence, investigation as to possibilities from a permitting perspective, from a land use perspective, from a contractual perspective. And it's notable that in this
Could I interrupt
case—
you just on that point, and I'm sorry to interrupt you, but was that issue ever raised, the one that you're arguing now, ever raised below? The inappropriateness of expert testimony on that basis?
It was. So there was testimony that was provided by the appraiser that was introduced on behalf of the taxpayer, and that testimony related to, for example, and I cite to this extensively in my brief, an alleged conversation that was had by that appraiser with a representative of Simon Properties. Simon Properties owns the remainder of the mall and the remainder of the mall property. And there was an objection raised at that time to whether it was appropriate that that information come in through the appraiser. That objection was overruled, and the testimony was accepted by the appellate tax board. So there was no direct testimony from MACY'S, from Simon Properties, from any representatives other than the appraiser who performed the appraisal. There was no direct testimony from any of those individuals, representatives of the mall or the MACY'S property itself, regarding the potential developability of these three pad sites. Or again, even though there were three pad sites submitted in the concept plan back in 2015, only one of them was incorporated into the Board of Assessors appraiser's testimony. He took a very conservative approach and only presented one of those for purposes of valuing the subject property for the 3 years at issue in the proceeding.
But maybe I misunderstood you. Was your argument that it was inappropriate to have experts testify to provide expert opinion about the developability as a general matter? That's what I was understanding you to be arguing earlier.
That's correct. That's correct, Your Honor.
Okay, thank you.
Yes, there's an argument that my sister advances in her brief, and I'll address it because obviously it was in the appellee's brief, and so it wasn't something that I proactively addressed in my brief, having filed first. But she comments on the Commonwealth's, what she calls the judicially recognized expert hearsay exception. And I appreciate that there is an exception to some extent for what would otherwise be characterized or categorized as hearsay when it's being utilized for the purpose of expert testimony or in connection with the introduction of expert testimony. She cites to the General Electric case, which is, I think, probably the most frequently noted case from back in the early 1980s, that speaks to this concept of expert hearsay. But I gave that case another read, and as I look at it closely, that case had actually commented on the fact that, an expert may use hearsay as a ground of an opinion, but that doesn't in and of itself make the hearsay admissible. I'm looking at an excerpt from that case. It says the expert must have some knowledge of the particular facts to enable him to bring his expertise to bear. He may not provide by hearsay the only evidence describing the property to which his opinion of value relates. And so when we look not to the whole property, but we look to this aspect of the property, the one that is before this panel today, these pad sites, or this one potential pad site that was valued, there was no direct evidence other than the evidence put forth through the expert appraiser introduced by the taxpayer regarding the potential developability legally, practically, of this possible future pad site.
Counsel, you said that there was an objection, and do you have a transcript cite for that? Because I'm looking at Mr. Bouchard's testimony at volume 2 around page 57, where he says that I asked folks at Simon, what about this? What I learned in that conversation was, yeah, we found out about it and said no way as far as the development of the pad sites. I said, why? He said, because we've got plans to do something on the other side of the mall. We didn't want it to be anyone else. It's as simple as that. And Macy's backed off. I don't see any objection in there. Is there some objection somewhere else?
There is, Your Honor. So I'm looking, I have the full transcript, which is obviously lengthy before me, but I'm looking specifically at page 27 of my brief, and I'm looking at footnote 4 and, footnote 6. And footnote 6 accompanies a statement that I made in the brief that statements about what Simon Properties said regarding what it will or will not allow to occur at the subject property were hearsay information, which, even if not objected to by the assessors, lacked a proper foundation. And then I, in my footnotes, say, to that end, the board's former counsel of record, referring to my predecessor, I didn't represent the board before the appellate tax board, but I say in the footnote, the board's former counsel of record objected when Macy's attorney prefaced a question asked of Mr. Logue with, quote, based on the fact that you now know that Simon Properties did not give its consent. The board's objection, board's attorney explained, quote, we don't know who Mr. Bouchard spoke to. We don't know what that person's position was. It's unreasonable to conclude what Mr. Bouchard was told in that conversation equates to Simon Properties denying any consent or withholding consent for the prospective pad sites on the properties. This is at pages 247 to 250 of volume 2 of the record appendix. And the presiding officer overruled that objection and allowed the question to be asked and to be answered. So additionally, Your Honors, and I cite to this again, a couple of cases in my brief. One is the Farmhouse Lane case. The other is the Vendatoli case. And these are both appellate tax board cases, which I recognize are maybe of some persuasive value, but they're not appellate court cases. But nonetheless, they sort of speak to the issues that were brought before the appellate tax board in this particular matter. So in the Farmhouse Lane Realty Trust case, which is a case from 2011, a taxpayer claimed that who claimed overvaluation was challenging a property that had been previously subdivided for 13 potentially developable lots. And the taxpayer argued that those lots could no longer be built, that the subdivision approval had expired. There had actually been a wetlands migration on the site so that some of those properties could not even, according to the taxpayer, be built upon any longer because they were now wet. And there had also been zoning bylaw changes that would have arguably prevented the development of these 13 lots. So similar to this case where it's alleged by Macy's that, well, we don't have proper permits or approvals. We've not done anything more than develop this concept plan for possible future pad sites. In that case, the appellate tax board ruled against the taxpayer and said, you know, it's too bad that you're alleging that this 13 lot subdivision that you once had approved is of no effect. But indicated that there was still a potential for development of that property. And it said here, quote, the trust never pursued permits required for the development of the property, never considered alternative development plans like reconfiguring the 13 lot development. So even in the absence of the requisite permits and approvals to proceed, the property's development potential, which again is what the appellate tax board cases generally speak to. It's not just what development exists on the site today, it's development potential. Otherwise, vacant land would be valued as nothing more than vacant land with no consideration for future development potential, buildability versus non-buildability. So in that case, the appellate tax board said no to the taxpayer. We're not going to allow you to obtain an abatement by virtue of you alleging that you don't have all the possible potential permits and approvals that you would require to develop a number of lots as part of a subdivision. Similarly, but somewhat differently, a few years earlier in the Vendatoli case out of Westport, again, a Mass appellate tax board case, the appellate tax board denied the taxpayer's claims that the use of its property for residential instead of rental purposes should have resulted in a different assessment. It was alleged that it was impossible because of problems with frontage and water source availability and access to use the property in the manner in which it was assessed. But the appellate tax board gave no weight to these sort of vague assertions that were being brought forward by the taxpayer. The appellate tax board reminded the taxpayer that the determination, the assessment by the municipality was deemed to be valid or presumed to be valid, I guess is the terminology that it used, absent credible evidence being put forth by the taxpayer, indicating that there were true legal impediments to redeveloping the property, and there wasn't direct evidence of those legal impediments. So I would argue that, much the same in this particular case, there's no indication that those legal impediments exist. The final point that I'd like to make, and this relates to the burden of proof, because it's something that, again, my sister speaks to in her brief as well. So I make a statement in mind that the Appellate Tax Board mistakenly assigned the burden of proof to the Board of Assessors. And I think my sister takes that quite literally and suggests that, never was it stated by the Appellate Tax Board that it was assigning the burden of proof in that manner. But, I wasn't saying it in a literal sense. I was citing to the case law, well accepted. I've got a handful of a string citation on page 28 of my brief of a handful of cases that stand for these sort of very basic concepts that the mere production of evidence is not enough to meet a taxpayer's burden, that the taxpayer bears the burden of persuasion on every material fact. So I've cited to all of that. And then I look, as I read along through the transcript, and I look to the decision of the Appellate Tax Board. The Appellate Tax Board made these conclusory findings. And the conclusory findings were that, it was too speculative that this one pad site would be developable. But it doesn't cite to the evidence that it's relying upon to reach that conclusion. And even acknowledging that there's a degree of deference due to the court below, or in this case to the Appellate Tax Board, there is an expectation that there's going to be something substantive in the record that supports, some direct witness testimony. Somebody from MACY'S indicating that, we investigated the zoning probability of this development. We had a conversation. We sought formal permission under the operating agreement from Simon Properties, and it was denied. Their own appraiser couldn't even cite the provisions within what's referred to as the COREA, the operating agreement, that would have prevented the development of these pad sites. So I think that that's telling.
Can I just ask one question as to that last point? Am I right that the Board of Assessors expert basically conceded that permission would be required under the operating agreement? Is that true?
Your Honor, that's correct. There was a concession. That concession was sort of a caveated concession, however. The appraiser representing the Board of Assessors indicated that, yes, there are these operating agreements that frequently exist with shopping malls. And one exists in this case, it's referred to as the COREA. But there are statements throughout that document that indicate that where permissions are required, permission shall not unreasonably be withheld or delayed. And so the testimony that the expert gave, the appraiser gave, representing the Board of Assessors, was that, yes, permission might be required, but the standard and the precedent is that permission cannot be unreasonably withheld or delayed.
And it was beyond the Appellate Tax Board's ability to determine that the representation that Simon had said, we're building our own restaurants and are doing our own development at Sears, was not sufficient to show that there would be a reasonable withholding of permission for competing businesses on the pad sites. Is that your position?
Your Honor, I think it might have been reasonable if there was some direct testimony to that effect. If there was testimony from a representative of Simon Properties, if the COREA was entered into evidence and cited to by a representative of Simon Properties saying, although we haven't formally, officially denied permission, if permission were asked of us today, me being a representative of Simon Properties and having the authority to speak for Simon Properties, that permission would be denied, I'd have a much more difficult case to make. That testimony never occurred. That expert never testified.
Thank you.
Counsel, thank you very much. We will hear from MACY'S.
Thank you.
Good afternoon. May it please the court. I am Laura Bellotti Cardillo, and I represent the appellee in this matter, MACY'S Retail Holdings, Inc. I would like to start by addressing the first point that was made with regard to the issue before this court, and that is whether the ATB erred in excluding potential pad site development from its conclusion of highest and best use. This is a question of fact. This is not a question of law. Appraisers are the individuals who are charged with determining the highest and best use of properties. This is not some sort of a legal construct. It is an appraisal construct. And so within the world of property valuation, it is appraisers who make that determination. And in doing so, they do evaluate the legal permissibility, the physical possibilities for the property, among other items. However, it is up to the assessor to make those, or excuse me, the appraiser to make those decisions. And that is part of the qualifications of an expert appraiser, is making the highest and best use decisions. And my brother would have you believe that because Macy's only had an appraiser testify, that there wasn't enough evidence to support the ATB's conclusion with regard to the highest and best use. However, it would appear that my brother would like to have it both ways. The board's expert relied in part on making a determination of highest and best use based on discussions he had with members of the town's planning department. No member of the planning department nor any other representative of the town was presented as an expert. So we do not have any testimony to support the board's expert's determination of highest and best use. In his report and during his testimony, he did testify to conversations he had with members of the planning board. Those conversations are the same type of hearsay as Macy's expert had with representatives from Simon, the mall operator, as well as any conversations with Macy's. So it is the same type of hearsay exception, and it cannot be had both ways by the town or the Board of Assessors. As you know, your authority in this type of a matter is based on the deferential standard. It's not plenary. And because this, you as the appellate court give deference to the ATB as the lower court tribunal, which has the experience, the technical competence, and the specialized knowledge to address these types of issues, which is what the board did in making its decision. And before the board could even get to a determination of the value of this property, it had to determine highest and best use. And time again, the way that the appellate tax board determines the value of property is after the highest and best use is determined based on the appraisers who are designated as experts in a case. And that's what they did here. There is no legal distinction. There's no legal requirement above and beyond the steps that were taken by the appraisers in this case. I'd also like to note that only the Board of Assessors expert determined that these pad sites had some sort of value to them. The town's original value did not include anything with regard to value for pad sites. That was something that was created after the fact when the board's expert saw a copy of that plan that was not necessarily submitted to the town. It was provided to the town for purposes of a discussion, a preliminary discussion. And those discussions, as the record indicated, did not lead to any actual development. Instead, it was the mall operator, Simon, that decided to develop the Sears parcel that it acquired. And that was part of the board's reasoning with regard to determining that the pad site development was too speculative. And I would like to point out to the court that contrary to what my brother may have said, the appellate tax board in its decision, and this is in the appendix on page 317, does enumerate the reasons why it found that the pad site development was too speculative. There were reasons provided based on the evidence that was presented by both Macy's and the Board of Assessors that led to the conclusion that pad site development was too speculative. And I won't take the court's time to read any of those reasons because they are in the record. As concerns my brother's references to Farmhouse Realty, and forgive me if I mispronounce, Vendituoli, those were factual decisions, much like this is a factual decision. And a distinction I would like to make with regard to both of these decisions is that the taxpayers in those cases were disputing the assessor's determination, and the assessor's determination that those rights had some sort of value to them. That's not what happened here. As I mentioned already, it was the town's expert that made the determination that there was value in these pad sites, not the assessor. So the original assessments that were appealed by my client did not include potential pad site development as an element of value. That was something that their assessor or excuse me, their appraiser, their expert decided as part of his highest and best use conclusion. And so at that point, it becomes a question of which highest and best use conclusion was supported by the record, by the evidence. And the Board of Assessors, their expert is the only valuation professional involved in the determination of value for this parcel that came up with this potential pad site development value. It was not included in the original assessment, and the MACY'S expert agreed with that. In terms of the my brother's representation that there was a caveated concession by the Board of Assessors expert with regard to permission for amendments to the Korea agreement, and that would not be unreasonably withheld or delayed. As the attorney of record for the trial, I can represent that there was vigorous discussion and on cross-examination of the town's expert with regard to the amendments to the Korea that had been granted previously. And those amendments all were for the benefit of the mall. Even if it was an amendment that was requested by MACY'S or MACY'S predecessor in interest, those were all because of actions taken by the mall that required MACY'S to then make modifications to their property to conform with plans that the mall had. So there was no evidence with regard to what was considered to be unreasonable or what was considered to be delayed. And so the appellate tax board, it was within their purview to determine, based on the evidence presented, what was more credible and making its decision. And in doing so, it found that it was not foreseeable that this development would take place. And as of the date of the hearing, which was more than 5 years after the first date of value, nothing had been started yet on this site. So essentially what they're looking to do is they are looking to ascribe value and tax a parcel based on an idea and nothing more. And the ATB decided not to adopt that approach and found as it did. And with that, unless there are questions, I will rest on my brief.
Seeing none, thank you both very much. It's a very interesting case and unusually well argued by both sides in an ATB case. The matter is now submitted